Heyo, folks! It is Friday, and we have some catching up to do. We have, you saw the thumbnail, and all the things. So today, YNW Melly hearing from yesterday. We have an update on the Delphi case, and as I'm sitting here, I see that today, Young Thug hearing about his stuff back today. So we have some stuff to do. So I mean, let's get right into it with. I believe the Young Thug hearing will start is scheduled to start at 9:30 in front of Judge Whitaker. So let's start with the YNW Melly. What happened yesterday? I've heard stuff about it. I'm not sure exactly what happened yesterday. I'm not exactly sure. But, I mean, hey, Patty, I'm feeling much, much better. Thank you so much. So, let's get right into this. And yeah, a hearing before the retrial of YNW Melly. And well, we'll just have to wait and see what this is all about. Might be about Miss Liberty, might be about Melly's ex-girlfriend being in town. I have no idea.
Okay, I'll go back on the record. Just on top of my page 3, state versus Vermont. 191872 CFNA. I've got Ms. Collins, Mr. Griffith, present for the state. I've got Ms. Liberty, Mr. Edelstein, Mr. Anson, Mr. Benjamin. Present for Mr. Devlin, who likewise is present. So today was on all pending motions based on our last discussion. The last time we were all here, I had asked each side to set through notice of hearing what motion you want to be here. The only notice of hearing that I can find that was filed by Ms. Liberty, February 8, 2025. It was 8 motions. Number 1, defendant's motion for order to show cause. The state of Florida's ongoing willful and flagrant violation. Court dated February 9, 2024. 2, motion limited to exclude James Howard's irrelevant and immaterial potential communication calls. 3, motion limited to exclude irrelevant and immaterial TikTok video of meat page. 4, renewed motion to take deposition of Christine Bradley. 5, defendant's motion to strike from the alternative response to the state of Florida's motion to allow former testimony of Felicia Holmes. 6, motion for scheduling. 7, amended third motion to compel forensic images of the deceased felon. And 8, motion to compel. So that's what I wanted to get done today. State, I'm being told that there's a medical issue with Buckley's X-ray. That's correct. Okay, she's on that. And what's your position as far as what you want me to do today?
So the other issue we have, and I wasn't present for the hearing Friday afternoon, but my understanding was the course of discovery, a notice of hearing deadline for Friday 5 p.m. It was moved to Friday 9 p.m. because Ms. Liberty was stuck in court and needed time to prepare it. The notice was not actually filed until Saturday, so they failed to comply with the court's requirements. So at this point, the state's position is no notice of hearing is properly filed and there's nothing to be heard today.
So you want me to do anything?
This also might have happened to public.
No. That's every what you want me to do.
The funny thing is, the great thing about those cameras in this room is everything gets recorded. I did say Friday at 9, and then I actually stepped back, so I knew I was setting myself up for failure next week. I do it Saturday. Taylor then responds, oh, as long as we get it before the beginning of the next business day, which is Monday. So they've had it. Most of these motions, Judge, were filed for over a year. I will bring the court's attention, because last night in preparation of this, I know the last time we were before, they objected then about hearing motions because they were filed under the tampering case. Yet they've filed several different motions saying it doesn't matter what case number are on the motions because the discovery is interchangeable. I'm quoting exactly the language from their own motion. So it's good for them when it's convenient, and now it's not convenient, so there's another excuse. It's been a year. Everything was properly noticed. I will also add, there's no written order setting a filing deadline or allowing them to file a response within a certain time frame. That was oral. So as we all know, Oral orders don't count for anything. They need to be written. There was no written order. I did ask to extend it. We are ready to go forward. There are two state attorneys sitting over there. Understandable. One of them is missing. Mr. Griffiths, is there something funny?
They'll be your
Ms. Liberty, you can direct your comments.
Okay.
Y'all
So we're
have 5
ready.
years to talk to each other about this.
We're ready
You
to
just
go for
start.
a judge.
Okay. Listen, State, I get what's going on. I'm not going to put anyone else done here, but I read all this and I went through the entire court file in preparation for the hearing today. Most of these are fairly straightforward. Over your objection, I'm going to hear them, but if we get to some specific factual issue that you say only Ms. Buckley has the particular knowledge to
Yeah. So the state says, oh, one of us is having medical issues. Can we do a postpone thingy on some of these things? And Raven Liberty, as there's two of them sitting over there, and the judge, I'm going to go forward. Yeah, folks, this, I think they have somewhere in this county, in this jurisdiction, I think they have somewhere between 150 and 200 assistant DAs. There really is no excuse for the prosecution to say, oh, we're not ready.
address. You can certainly tell me that, but yeah, I find most of these to be very straightforward. And I think you probably would. So that's over the state's objection. So, listen, let me just do them in the order. And let them notice. So number one is defendant's motion for order to show cause by the state court should not be found in contempt for ongoing willful and flagrant violation of court order dated February 9th, 2024. I did read the motion on all of these. I read all the motions. If there wasn't the authority cited therein, I did review that as well. Ms. Liberty, I went on CMS yesterday and I went on Odyssey. I can't find any court order dated February 9th, 2024, nor any order that you referenced on a motion for rehearing February 16th, 2024. So if someone could show me those two orders. Okay.
Oh, and I think I may have put it in the motion, that you see an order from the homicide, they take the appeal, and I believe it was late December, so then you see orders coming from the tampering case, so that might be where the confusion lies, is there was two motions for rehearing. I filed the motions to compel, we came into court, the court had ordered that they comply with it, they filed a motion for rehearing. If you want, I can pull it up on the tampering case, because more than likely where it came from.
Is that what it is? I mean, I can pull it up. You tell me it's not in 1970s here.
Yeah, that's kind of why initially I had this filed under 2023, because it would be easier for the court to file, state objected one, and everything filed under 2019. Or we could take that one off, and I'll take a break and I'll pull everything up to its head.
No.
Good morning, Isabella, Robin, Gwendolyn. I saw earlier Mike, Christine, Serenative, it's Trinton, a little darker, Fondium. Who else is here? Robin, hello, and a bunch of people over at YouTube. Hello to you over at Rumble, and hello you guys at X. Yes, streaming on 3 platforms here. Hit the thumbs up, hit the subscribe button or follow button, or yeah, follow. Okay, let's get
So I found the order. This is case number 23-105946. It's Murphy entered the order on February 9th, 2024. It says this cause being before the court of the defendant's motion to compel discovery filed on February 6th, 2024. When the state filed a response, the court held a hearing on February 9th, which granted. Judge Murphy subsequently entered an order denying the state's motion for rehearing. That's on February 16th, 2024. There's only one motion to compel from the defense filed on February 6th, 2024. And I'm looking at it right now, I just read it. And I don't see any reference to the 4 items that you put in the present motion.
Would you look and see if there was not another motion to compel possibly a reasonable?
Well, I'm just looking at Judge Murphy's order. He said this order is related to the motion to compel discovery filed on February 6, 2024.
So there's actually,
That's the motion to compel filed on February 6, 2024.
so there should be two motions for rehearing, filed by the state going to two separate orders, and then the judge denied both of those two separate orders. So there was two motions to compel, and I believe in the one motion to compel, it was going directly to the information regarding, certain emails.
What, did Judge Murphy enter the boardroom?
Yes, so if you want to pass, I'll pull it all up so we can read it and make it a little bit more complete. I'll pull it up on break, so you can just go along quickly, but there were two motions to compel, and there were two motions for rehearing.
Was there two original orders?
There should be two orders.
Okay, so we'll pass on that.
So the next one would be James Howard's phone calls.
Yeah, number 2 is defendant Jamel Denham's motion limited to exclude James Howard's irrelevant and immaterial detention communications. So you're talking about, this is a motion limited for trial. When I read the motion, anything else you want to tell me in support of your motion?
This judge was close to, I want to say 84 hours worth of phone calls that were given to us that December. We were set for trial. I was always of the position it was given to us that late in the game in order to make it continue it. Nonetheless, I had a group of students go through those phone calls along with myself and the investigator. When you look at the police report that was authored by Garrett Steele, it starts referencing the investigation that's being done by Danny Polo into this James Howard, and I believe the Albany. He, for some reason, then references James Howard in this police report, saying he was listening to phone calls by James Howard, and then he hears James Howard telling somebody on the phone call that he has to do something for Melly that day. We had the opportunity to depose Detective Polo as well. I asked him this very question. I told him over 80 hours for the phone calls. There was one phone call, and that one phone call in this batch of phone calls tells us nothing other than him saying, "Oh, I have to talk to Melly today. Not I have to do something for him. Not I got to call people for him. Nothing at all." During the deposition of Detective Polo, when I started questioning him, "Hey, I went through all these phone calls. Could you please direct me to what phone call I should be looking at? What batch of phone calls?" He then tells me, "It's not this batch of phone calls. It's a batch of phone calls that would go back to 2020 and 2021. We are dealing with the tampering. I believe we're spanning from April of 2023 until August of 2023, somewhere in that time frame." Detective Boland's own words was the only time that he had heard James Howard talking about Melly would have predated the incident, i.e. 2020, 2021. Nonetheless, those phone calls are not in this 84 hours of phone calls.
Okay, I just learned from Kathy Rutten that the Young Thug hearing about his seized items that was supposed to be this morning has been cancelled. So, okay. So no update on that today, except cancelled. Damn. I was looking forward to that one. I was really looking forward to hearing more about that. It would be fun to hear George Whitaker give an order to either Miss Love or to the Gaither or whoever's, just give him his stuff back.
There is still the outstanding issue of whether Mr. Dennis still wants to study about the income, so to raise the issue for the conflict of interest, the court pointed that out. That was going to be one of the first things we were going to address to you today, and we still need to address that, because obviously if he does not want to represent the account, then there's an issue to issue that to the party.
I mean, that's his call. I already had a discussion, so I'm sure if there's something that you want to let me know, you're going to let me know. Any response to the motion?
Yeah, so the state filed a written response, I believe it was yesterday. This is one that was properly prepared, but as pointed out in the argument, the state is not required to disclose which calls it intends to use at trial. But other than that, we are going to rely on the responses.
So I did check the docket this morning. I saw no written motion. And it's funny, Judge, that they were starting this hearing after they wanted to continue it because they didn't get proper notice of a notice of hearing from, I don't know, almost 2 weeks ago. But in the evening, they filed something before Ms. Buckley went to the hospital.
This is the second time. You need to look at me and address things to me. I could give you a lot of adjectives about what I think of this entire procedure. funding's not gonna be one.
Okay.
So, anything else you want to tell me about this?
Maybe I check.
Ooh. Judge has adjectives to say about this. Oh, this defense attorney is really cringy. That is Miss Raven Liberty, who the prosecution have been investigating of witness tampering. I covered that a couple of weeks ago, and it's complete garbage. Complete garbage. They are accusing her of witness tampering because they found. If you were watching the first trial, you had that former undercover cop who, in the ski mask, in the baklava, who needed to have it because reasons. And then the defense found out, oh, your wife posted your picture. And just because the defense found out, either by anonymous tip or just research, they decided to investigate her for witness tampering, for finding stuff out like a proper defense attorney does.
I would say there are no material phone calls that would even go to the nexus of witness tampering.
Okay, so, this one, and I'll enter the appropriate order to be denied without prejudice. I have no idea what is or what is not going to be relevant. And without hearing the evidence at trial, there's no way that I could. I can't make the state try their case in vacuum. But just without prejudice, you can certainly raise the issue if the state tries to introduce any of these phone calls at trial. Give the appropriate objection, and I'll give you the appropriate ruling. But in a vacuum, having never heard any of these calls, I have no idea what the calls are, nor do I have any idea what the evidence is going to be at the trial. So that one's going to be denied without prejudice.
So Judge, I had for the state report client emailed and asked your chambers how you wanted to proceed with some of these videos. So the next one would be a TikTok video. We can show it, or I can give it to chambers. That's what I didn't know twice in the past. We usually have provided it, and then you watched it.
Well, listen, I'll let you argue what you want, and I'll let the state respond if they want, but for all of these, it would be the same thing. I don't know what the evidence is going to be at the trial. There's actually already been a trial, and the evidence may be the same as the first trial, or it may be completely different. I have no idea. But I can't make a decision now without there being one witness, without being one piece of evidence, without hearing the answer one question in anyone's testimony. You may be right. These things may be not relevant, and the state may not even try to introduce them. But I can't give you a pretrial ruling, again, in a vacuum when I haven't heard it.
So how would you, I'm just curious, how should we proceed? Because I mean, you have to do the pre-trial one, since we are seeking for pre-trial rulings to keep out certain evidence that's not relevant. So the next one on here would be a TikTok video, period. We're dealing with i.e. homicide. This video is after the homicide. I don't even believe the individual in the video, which would be, and excuse me, I'm gonna see her name, Geneva Molina, doesn't even know Mr. Dennis. So there is no relevancy to the homicide and my client. If it was filed, I guess, because they have it interchangeably with the tampering, there is, I guess the tampering was seen would be Mariah Hamilton. There is no evidence in that video of Mariah Hamilton. There is no evidence in that video of anything, period, that has to do with this tampering case or this homicide case. I believe it is the state's burden at this juncture, not our juncture. It's not relevant, period.
I don't agree with you. It's not the state's burden. This isn't the trial. So, state, anything you want to tell me?
No, we would ask Dr. for ruling depending on whether or not it comes out of the trial. Depending on the evidence, it may become relevant. I provided, and we can't tell you at this time that we, at least we can't say we don't. We provide it to defense, and should it become relevant in trial, it will be subject to all appropriate relevancy objection that we can address it then.
Thank you. So, for this one, I'll enter a written order. Again, the defense motion is denied without prejudice. Certainly can bring up whatever appropriate objection you need to at whatever time you feel you need to, if in fact the state ever tries to introduce it at trial, which maybe they will or maybe they won't.
So
So that's number three.
just to make sure that I'm following the court's ruling, and if it comes to the trial, should I then file a renewed motion to eliminate? So it can be argued in trial, or should it just be readdressed? Alright.
Number four, renewed motion to take the deposition of Christine Bradley. I did read the motion. Anything else you want to say?
I would just say Judge Murphy had already entered that order, which I attached, December 18th. And it says, after such emails are reviewed, if defense still wishes to depose ASA Bradley, counsel shall file a written motion. So I did that, I think sometime in February, close to a year ago. I wrote it out. At this point, we need to depose her, especially in light of all the things that I went through, and I amended this motion to add a few other things that have happened in the deposition. I need these emails. They get even more confusing. Your lead detective on this case, Garrett Steele, said under oath that he never read these emails. These emails are referenced throughout the affidavit and the arrest, stating that the deposition and these emails prove there was an official proceeding that Mariah Hamilton did not go to. Again, Garrett Steele said he never read the emails. Danny Fuller then says it's not his case and he can't comment on the emails. It's really unclear from reading them what's happening. And again, there were certain emails that were not even provided by the state that we later were given from other sources.
State your response.
First, that's an inaccurate statement. The emails were actually provided. That's actually in the state's response to one of Ms. Liberty's other motions, returning specifically this one. State filed a response back on January 2nd of 2024, and we're relying on that response.
In the 19 days or 19 days. Give me the exact date.
Copies furnished January 2nd, 2024.
So, State, let me ask you this, is Ms. Bradley listed as a witness?
No.
She's not. She's not your call.
No.
Yeah, she listed by you all as a witness?
Yes.
So, the defense lists a witness, she uses rules, and you intend to call her.
Yes.
So, you don't know what she's going to say, but you intend to call her as a witness?
We do intend on calling her as a witness, because she has, I believe that because as far as, or correct me if I'm wrong, as far as the other issue before she testified, anybody, no, all right, she wasn't there. I want to
Tell me what you need to,
It's very
give me a couple of questions you want to ask her.
I want to get to what other emails were there that she had between Christopher Barris, showing the efforts to get Mariah Hamilton to this deposition.
So with Ms. Hamilton, that's the person who just got put on an ankle monitor.
Yes,
So let's say Ms. Hamilton now shows up and testifies, what's the relevancy? So she's gonna be here, she can be subject to examination, consultation.
if we still have a witness, depending on answering, we have to get to the bottom line, which means that arrest report is referencing April 18th. It's going on to say that they looked at emails provided by Ms. Bradley that show these efforts to get her to this deposition, which is weird because we don't have those emails and any efforts to get Ms. Hamilton to a deposition. So we need some clarification from the previous state attorney when you talk about these efforts to get her to deposition. And then you're provided emails, and those emails tell us something totally different than what's being.
Is Ms. Bradley listed as a witness in the 23 case?
She is not.
Is she listed by you as a witness in the 23 case?
Not at this juncture, those states are the appeal before we got that far. And this again was a motion that was pending, coming up to getting a.
Well, do you want to ask her questions about homicides, or do you want to ask her questions about tampering?
About the tampering thing.
And she's not listed as a witness in either one, by either side in that case?
Okay. So with the tampering, this motion had initially been filed. We hadn't got to the point where we were going to do with, I had not did a witness list yet on the tampering. She is listed, however, on the homicide.
You?
Yes.
It seems a bit scattered, the arguments here, and I don't know why.
So Judge, the rules provide I can take depositions of anybody with relevant information, which Ms. Bradley is, whether she's
Yeah, I
listed
agree. So
or
you're
not
waiting,
listed.
you-
Because they filed a protective order and won't allow me to do it. That's why I had to then file the first motion.
All right, so Mr. Gertz, I'm looking at 3.220 subsection H, discovery depositions, and this is 1A. The defendant may without leave of court take the deposition of any witness listed by a prosecutor as a category of witness or listed by a co-defendant as a witness to be called at a joint trial or hearing. That's not Mr. Bradley in this case. But then the next sentence says, after receipt by the defendant of the discovery exhibit, the defendant may, again, without leave of court, take the deposition of any unlisted witness who may have information relevant to the offense charge. So don't they get to take your deposition?
Except for the fact that Judge, she is a state attorney, and her role as state attorney, she was entitled to protection, she filed a protective order, in part because
Okay. They want to depose the former prosecutor. The prosecutor who was thrown out by the previous judge from leading this case because of misconduct. Now the defense wants to depose. And for me, yeah, go ahead. Should be granted.
everything that Ms. Liberty is asking for has been turned over. Emails, whatever else she's been looking for, has been turned over, I believe actually several times by Ms. Buckaloo, again, which is one of the issues going forward today, not having her here, but she was the one who provided copies of everything.
Yeah, but she was thrown out due to misconduct. That in itself should warrant a deposition. Because you obviously, previous judge did not trust that prosecutor to continue. So why should we trust she actually turned everything over?
She's not assistant state attorney assigned to this case.
Ms. Bradley? No, she's still, it's no different than if somebody is a case filer or works on a case. There are work product protections involved in terms of what Ms. Liberty
Oh, that's
has
cool
asked.
crap.
We sought that protective order because
You were ready for trial in 2023. And now you claim work product protection? That's just stupid.
she's entitled to those protections as a prosecutor, and also because based upon our response, that it is unnecessary. I'm sorry.
Did someone grant the protective order?
I believe that was a hearing that Mr. Klinger conducted back in like November of last year, but I was not party to that.
So that's where we did this order coming down on December 18th. And then Ms. Buckley was ordered to provide emails, and if I was not satisfied, as the order clearly states, write the motion, so I could depose her, so I've written the motion. I am looking at what she provided.
I guess last word, Ms. Liberty, I'm still not following what the relevance is. Tell me what, let's say she wrote 1,000 emails back and forth. What is the relevance?
Because if you go to the arrest affidavit, under the witness tampering, these emails that Ms. Bradley authored are specifically referenced in Garrett Steele's police report, right? He says that he reviewed emails between Christine Bradley and defense counsel coordinating the deposition of Mariah Hamilton, that she showed her numerous attempts to get Mariah Hamilton to this deposition. That is Garrett Steele's words. We deposed him. I put it in the motion. Garrett Steele then says, I never read a single email. I'm depending
I
on him.
mean, his report's not gonna be in front of the jury. I mean, none of that's gonna be in front of the
I know, Judge, but when I'm moving to set up every element of this witness tampering case, it seems more and more that it was filed out of being vindictive more so than anything else. It is relevant to these emails because it is part and parcel of everything of the basis of arresting Mr. Dennis. They weren't saying Mariah Hamilton didn't show up to trial. They said Mariah Hamilton didn't show up to a deposition. The other reason I need to depose Christine Bradley because it's really important how that May 5th date was given, all right? So when we're trying to go with the premise that my client tampered with Mariah Hamilton because she didn't go up to this deposition, we need to hear from Christine Bradley and find out what effort she made to coordinate this deposition with Christopher Barris. That is why she was also supposed to turn over these emails. And guess what? When you read these emails that get turned over, Stuart Adelstein's emailing with Miss Bradley, trying to ask for dates for the deposition. There was not one single email that was provided to us in Miss Buckley's response from the time that Christine Bradley gives us dates to the time that Stuart picks up. She was not contacting Mr. Barris. That is, we can't see that at all from her emails. We finally get an email from her, April 18th, that's copying an email from April 17th. That appears to be the first email that she sent to Christopher Barris about this deposition. So for the state to not coordinate a deposition with a witness and then to cover up their negligence, turn around and file a criminal charge against the defendant, when in reality, if we got her up there, we would hear from Miss Bradley that she never properly coordinated this deposition, that she never told Christopher Barris, and all the months leading up to us trying to schedule this, Mr. Barris, from these emails, was never contacted. And that's what we need to depose her about, the efforts that were made from her. There is an email in here also that was provided where she talks about numerous phone calls and text messages that were sent to Mr. Barris. I don't see those. We don't see the numerous text messages. We don't see the numerous phone calls. So we need to depose her on this limited subject of what she did.
Okay, so I just read the information in 23-10594 CF10A. I'm also, I just read the standard jury instruction 21.90, which is tampering with witness, 3 elements of the statement that prove.
It's official proceeding, they don't prove it. I know that. I did the deposition of Barris, you know. He can't even tell us what a subpoena is. He kept saying, that's a lawyer word. When I asked him, under the statute, tell me what official proceeding is. He goes outside of the statute and tells me anything that's involved with the lawyer, that's an official proceeding. That's your lead detective. They want to kill my client. That's what we're playing with his life.
Stop, wait. You just told me this has to do with the tampering case. No one's getting the death penalty for the tampering case.
Yeah, but they want
Ms.
like,
Bradley's testimony in the murder case is totally irrelevant, so.
they want
Let's go
like.
back. We're talking about the tampering case, we're talking about the.
We are talking about the tampering, but they're also intermingled with each other. So it's life in prison.
Okay, I got it. Respectfully, over the defense objection, renew motion to take the deposition of Christian Travis and be denied. So I'll entertain a appropriate written order. I don't find that her testimony would be relevant in any way, shape, or form. It's not relevant in a homicide case, nor do I find that it's necessary under what's been followed in the tampering case, information or what's required to be proven pursuant to the jury instructions. But you're telling me you listed her as a witness, that means you have good faith belief that you're going to call her as a witness, so you can call her as a witness. Ask whatever questions you want from the jury under oath, but that's going to be denied. Next, number 5 is defendant's motion to strike.
Judge, can I just ask for a finding of fact when you write that over, please?
Everything that's stated on the record.
All right.
Defendant's motion to strike and or in the alternative response to the state of Florida's motion to allow former testimony of Felicia Holmes. So this kind of mirrors the same as 2 or 3. I mean, I have no idea if Felicia Holmes is going to, she testified at the
She
first trial, right?
testified in the previous trial, Judge. We actually started to address this motion in the previous hearing on Judge Murphy. Ms. Adelstein actually put a stop to it because he brought up the issue that the court has brought up, which is until she actually takes the stand, we're not outside the presence of the jury, we're not actually going to know what she's going to do. She has filed through her attorney a notice of her right to invoke her Fifth Amendment privilege. I believe when she was in court, she was either going to say she was going to invoke her Fifth or say that she didn't remember. But I think what's going to end up happening, as Mr. Adelstein suggested at the previous hearing, once we
Yeah, as the World End says, it's nasty if charges filed for non-attendance at a deposition she didn't have notice of. Yeah, I mean, this prosecution is a Foster clock from start to finish. And the previous prosecutor who was thrown out, there's so much misconduct being done in this case. So just having her on the stand and ask her questions, I don't think that's enough. They need to have her deposed. And then if she suddenly starts saying something else on the stand, impeachment.
get her as a witness at trial, she'll be brought in outside the presence of the jury, and then we'll have to come up again for
So you want me to defer on this until we have a proffer from her? And
Correct.
Okay. Is there anything else you want to tell me about your motion to strike, or the alternative, you want me to consider it as a response?
I wouldn't
If the
consider,
state does at some point ask to allow her former testimony, which I guess you're not asking at this point.
We can obviously anticipate her invoking or saying she has no memory, but until it actually happens, I mean, she might not show up, which is another issue, which we might then saw.
she's on a bracelet, but she'll show up or listen.
Okay.
Right, but until we reach that point.
Anything else you want to
Yeah,
tell me
Judge,
about?
they filed this motion, as I put forth in my motion to strike. Actually, Ms. Bradley filed it, they incorporated it, they have not withdrawn it, so it's their intentions to move forward. Mr. Griffiths is correct, she does have to show up here and testify. That's why I put that email there that Ms. Bradley sent. And if you actually look at the response to Ms. Buckley was supposed to turn over all these emails, she never concluded that email conveniently. But that email is sent the day before this motion is filed, saying what? I've done all the research, and from my research, it shows that Ms.
And folks, before we continue with this, hi Mo.
Hi, how are you doing?
I'm doing much better. Thank you so much. I'm doing fine. I'm doing fine. Every
That's
time I'm
good.
covering is a clusterfuck. Did you know that?
I just started a new cluster F trial that I think we need to look at
Oh,
because holy God, look up the Barnes. So South Carolina versus Brandon Barnes. You have a love quadrangle. You have a secret love child, and three of the world's dumbest defendants together.
okay. Yeah, we can talk about that, but I need to get through
Oh, well,
this
no, I
one
just meant in future, not
in
now.
future. Okay, okay.
I meant just as, in case we run out of cluster Fs, we
Oh,
have one on standby.
somehow I don't think will be an issue. The lack of Foster clocks.
Yeah, I
No.
don't see it being, but,
Oh,
just in case we run
just
out.
in, yeah, just in case. I will have that in my pocket, just in case I cover a trial without any Foster clocks. Yeah,
Yeah.
yeah. Now, I don't know how much you heard about this, but they are now talking about deposing the prior prosecutor for. She was supposed to turn over a whole bunch of emails regarding a deposition. And then she turned over a bunch of emails that had nothing to do with the depositions. And now they want to depose the former prosecutor. In the first trial, the prior judge threw out that prosecutor, saying, "Nah, you can't try this case due to misconduct and everything. So now the defense wants to depose her because she's hiding stuff from the.
Yeah, I
she's
mean, that
hiding
would
stuff.
seem. I hope the judge doesn't let them get away with these shenanigans again.
Yeah, I don't know. I don't know. I've been listening to because the judge wants to expedite so they get to trial and say, well, put her on the stand. You can cross-examine her. And then the prosecution is saying work product protection, and she will probably plead the fifth. And oh, yeah, but this is. I don't remember if this is Miami-Dade or if this is under their umbrella, but these are the type of prosecutors who needed an attorney to help them with their ethics, how to turn over evidence, how to everything. And they
Well,
got
Steve
one.
Gosney is from
Yeah.
Florida, so
Yeah.
we could have him teach a remedial class on ethixology
Yeah,
too.
and then they wrote a hit piece about him, and now he's not
Well,
teaching.
yeah, he might not want to help them anymore.
No, I don't think so. I don't think so. All right, but let's continue here.
Holmes would have to show up to court and plead the fifth. I'll file the motion if she shows up to court and pleads the fifth, and then she doesn't have to come back here anymore. I find it disingenuous and unethical for the state attorney to be advising a witness to plead the fifth on the stand, much less advising them how to testify whatsoever.
Didn't she have her own one?
She has her own lawyer, Mr. Barris.
You're not giving.
I'm certainly not giving her any advice.
But that is Ms. Bradley.
Ms. Bradley is no longer
Ms.
the
Barris, but you are moving forward on her motion. So that is Ms. Bradley telling Mr. Barris that your client needs to show up and plead the fifth. So now Mr. Griffiths is saying, oh, we are going to move forward, but she needs to show up and she needs to plead the fifth. If it's his intention and he knows that she's going to plead the fifth, it's not proper to bring that up in trial or in front of the jury.
Well, I agree. I mean, that won't happen in front of the jury. If I don't remember it on my own accord, I'm sure you all will remind me, and I'll send the jury out. We'll bring her in outside of the presence of the jury, put her in her oath, and see what she does.
So what it sounds like is he's actually agreeing, judges. They're not going to be moving forward their motion to have her deemed unavailable. They have plan on having her come to court, so I move this right to motion because that's what they're saying themselves.
I'll defer on your motion at this point. It's not granted or denied. It will remain pending. We'll do it properly with Ms. Holmes at the appropriate time. They decide to argue whatever they want to argue. Maybe she'll just decide not for everyone's question. Okay, number 6, motion for scheduling order. So I read this.
Yeah, this judge is in a rush because he's been telling the prosecution and the defense this trial is happening in September. So get your shit together, because one of the prosecutors can't be there today, so they wanted to. Can we talk about this on a later date? And no.
So
there are two prosecutors at the table. You have 150 employed. Get on with it.
Yeah, so is he like a working intern then, or is that maybe one of their backbenchers?
Yeah, I don't know. I don't know. But there are two there, and the judge forced them. Yeah, we are doing this now. If it's an evidentiary issue that only that prosecutor can handle, then you need to tell me when we get there. But he's running through these.
Now, I haven't been up on this one, but has it been mostly the state slow walking this, or has it been a combination of both the state and defense having legitimate continuance needs?
No, purely the state.
Okay.
Yeah, this is the case where, if you remember the former undercover cop who testified in the baklava.
Oh yeah, that guy.
Yeah, and then they found a picture of him online, and then he had to testify without the baklava. And the investigators decided to start what was it? The tampering with witness investigation against the defense for finding his picture. And they kept it a secret from the defense for over a year. They got Raven Liberty. Do you remember? That's her who is there. They, through a subpoena, got all her iCloud. All of it.
Okay, but we're arguing about work product.
No, that's a separate issue.
Well,
Now
no, but it does seem to be arguing from not a place of having any sort of ground on which you could stand if you're arguing that your state's attorney's work product is protected, but you go behind the back of someone and get their entire iCloud, which could contain work product
Yeah.
on this. It does seem a bit rules for me, not for thee.
Yeah, and this apparently has been going on this entire time, with the prosecution hiding and lying and cheating, and yeah, but they're still there. And what is it? Melly has been in jail for 2,200 days.
It boggles one's. I don't think we're going to run out of clusters. I take back my initial assertion that we're going to run out. I think we're good.
Yeah.
And I also did review again 3.220 subsection H, the discovery deposition. And I quote, "A party taking the deposition shall give reasonable written notice to each other party and make a good faith effort to coordinate the date, time, and location of the deposition to accommodate the schedules of other parties and the witnesses to be deposed. Notice shall state the time and the location where the deposition is to be taken, the name of each person to be examined, and a certificate of counsel that a good faith effort was made to coordinate the deposition schedule." So at the end of the day, I consider this more of a professional courtesy. If the parties want to be courteous to each other, that's always kind of preferred, I guess. But if the parties don't want to be courteous to each other, you don't have to wait for the one state attorney to tell you, set the deadline.
Okay.
Mr. Devens has now been in custody for 2,202 days, okay? And if one state attorney is not available, maybe one of the other two assigned to this case can stand in. And if all three are not available, maybe one of the other 150 state attorneys upstairs can consider it, but you won't have to wait on that. So,
Thank you so much, Judge.
I mean,
just so you're clear, you're not advising Ms. Liberty unilaterally set the motion.
no, it's not unilateral, she can coordinate.
Coordinate with us.
If I'm getting, I read the motion, she says she's, I mean, I have one state attorney who can tell me he's working 1 day a week here, is that right? So that's 80% of the time it's off the table, and just being told that I can't show up these depots, I won't do it. You don't have to wait, set the depots, subpoena the witnesses. If someone doesn't answer a subpoena, file the appropriate motion, and I'll conduct an direct criminal contempt proceeding. But it's time to move forward.
We are moving forward, Judge, but we also, the other issue has been is that Ms. Liberty must properly coordinate and must properly notice the state. This is a return, I know, but
I just read the rule. She doesn't have to coordinate anything. She has to make a good faith effort.
Right, she has to make an effort.
She has to put a certificate on the bottom that says, so I tried, they told me no.
So what has happened in the past is that she has asked for dates, we provide dates, and then she schedules dates out or times outside of them.
Judge, he's actually lying to the court right now. I sent it out every
Please,
email.
please, stop. She's gonna set her down. She has to put a certificate of good faith on the bottom. You all feel that has been submitted in error, you file the appropriate motion, and then what would be a wonderful use of this court's time is I'll have a hearing with 6 lawyers, 7 lawyers, because you all can't say no. So in case I'm not making my feelings on this point clear, I'm not prejudging anything, but talking to a judge about trying to agree to set depots in the death penalty case is absurd. I'm embarrassed on both sides. I'm embarrassed. The motion for scheduling order is denied. You don't need a scheduling order. Set your depot. I'll enter the appropriate written order. Next, number 7.
Oh
Yeah.
gosh, this is where Dad's no longer angry at you. He's disappointed at you.
Yeah.
He's questioning, like, did I stand next to Chernobyl? How did my genetics create something as dumb as you? Like, and that's the kind of vibe I get from this judge. That's like, did y'all eat lead paint? I mean, I feel like I'm watching my kids, argue. This is so unbecoming. And, having maybe not the full scope of the entire thing, I will say that the state does seem very douchey. But it could be that his face just naturally looks like he is directly next to something that smells like dog poo.
Yeah,
Look at his face next time he turns around. He has resting, I smell something really bad face.
Okay. Yeah, I mean, there are a lot of resting face. I mean, I have a resting serial killer face, and so that is why you will never see me in court doing trial stuff, because when I'm focused, I'm going. Yeah. My passport photo, I'm amazed I get let into other countries.
Yes.
Defendant's third motion to recall the forensic images of the cell phones belonging to Christopher Thomas and Anthony Williams. I read this motion. So State, let me start with you on this one. Do you have anything from the cell phone downloads of Christopher Thomas and Anthony Williams that has not been turned over to the defense at this point?
Judge, again, this one is Ms. Buckley's purview, so she filed a written response back on. Sorry, or just the other day. May 20th, 2024. I think the issue that Ms. Buckley had, and I'm probably going to be speaking out of turn on this one, is that there are contents of the phones that are not relevant to the case. And so some items have been turned over, but not all the items. But I am not, this is one where I am lacking now.
So she decided.
I was wondering if the state could decide what was relevant in a case or not.
Yeah. I mean, we decided it's not relevant, so we just didn't turn it over. That's really not up to the state to decide, because especially when a prosecutor has already been thrown out from the case, the lead detective was more or less in contempt because they found out he was lying. I mean, no, I wouldn't trust the state with anything.
Well, no, especially, again, you don't know what may be exonerating until you do a deeper, evidence dive. And if that one piece of kind of disparate evidence isn't in there because they thought it doesn't relate to anything, you're starting off already weak. I mean, I thought that, or I was under the impression that you just got the same, Cellbrite data dump that the state got.
Yeah, but as it turns out, no, because the state got it, then should turn it over to the defense, and then the state decides, this is not important. Well, we will get into not turning things over in the Delphi update.
Yeah.
That
will be interesting.
That's okay. The state doesn't get to decide what's relevant and what's not relevant. These are the homicide cases, right?
Yes.
Just turn over everything in.
Well, Judge, I can tell you, I'm a partner. It's not necessarily we have to turn it over, we have to make it available for inspection. We
Yes.
have a number of days. We
Okay.
scheduled that. We told them they can come again. There were multiple days when we sat there, waited for their investigator, came hours late.
She's like, yeah, so I would
If I
have
may
to
finish, Your Honor, I was the one who was personally there that day with him and our investigator. We continue, anytime they want to come see it, we have had an investigator from our office, the computer, and their investigator there. Sit
Is
down
it
and
something
look
where they
anytime
can
they
just
want.
stick a thumb drive in and download what you got and that's it?
Make a copy of it? No, Your Honor.
So who
Why
told you?
can't they do that?
As Mr. Griffin said, Ms. Buffalo is on the most knowledge of all the contents of the phone, and that's why it's all discussed in her response. But regardless of the obligation to make it available, we have and continue to anytime they want to
Let's make it
schedule.
available. One of the things
For
to make it
inspection.
available for is to copy it. They're not
If it's
gonna copy
available to be copied. Ms. Buffalo, and that's why I did this one of the motions, we said that she would be prepared to argue, is of the opinion that she
it. You
filed
already
the
went
whole.
to trial. You already went to trial?
And it was.
You already went to trial.
Yes,
This is the decedent's cell phone. Okay, over the state's objection, this motion is granted in full. Make the appointment, go over there, download everything that they have.
I'll drop off the July 10th.
oh, no, they have to copy.
Yeah, you gotta come do it. That's what the rule says. Available for copy inspection, so it's available for copy, so go copy.
This is what, my suggestion, because it's solid right download, if they wanted to copy it, now I can have my expert come and do an actual rip of the phone then. Can I do
And they can write it down,
They
based on digital
can just
forensics.
copy what you have. Don't you all have it done?
Right, their expert can do that, but as she's suggesting, she wants her expert, we can absolutely do it right, we really set up an appointment with BSO Digital Forensics, and they do a download with them, their
Or they
process
can give me their download, I don't understand where I, for the now, for the first time, have to go to their office to do a download. I've never, they usually say, bring us a drive and we'll download it for you.
What do you want? Which is your preference?
I will get my expert to do our own download
Okay.
of the phone. So where we need the parameters though, so when.
There's no
where-
parameters, just make an appointment. Listen, I'm not gonna make appointments.
Okay,
If you all can't work that out, I don't know what to tell you. Okay, go appeal before DCA and say, we can't make appointments and treat each other like civilized human beings when we have to come over down.
so that's it, I'll have
You
my
get to
expert
download.
contact them.
And I just wanted to be
I'm
clear
gonna-
on the state response.
I like
that
covering
Buffalo
this
filed, she
case.
wanted to argue.
I like this
Everybody
judge.
does
Yeah.
in there numerous times, cite how that would be a departure from the essential requirements of the law based on all of the 10 pages that she filed, so.
Listen, I understand. I understand. I review the motion. It's a capital case. Again, I want to do it. It's a capital case. She's gonna download it. That's the rule. Last, number 8. The motion to come out. Mr. Aidelson, this is your motion. Yes, sir. I did reach.
Yeah, Melly needs to learn how to not do the self-soothing thing. That it does not have a good look at it. But I understand him. He's been in jail for 2,200 days. He was 19 when they put him in there. He's 25 now.
Hopefully,
with
this will
limited
be.
human contact.
Maybe that's something that his lawyers can really work with him, because I do think that with everything that's come out with, and we'll get there eventually, but I think that we are learning that juries are not paying as much attention to the evidence, and they're looking a lot more on these sort of ephemeral, like, gut instinct sort of things when they look at the suspect. And then they kind of say, oh, well, she had shifty eyes, or, they were not looking at me when they brought such and such evidence out. So that's why I knew that they were lying. So it will be interesting to see if that's something that they can give him tools to kind of counteract when he feels himself getting, write notes, look like you're doing something, talk to me, talk to this person. What the
Get squishy. I mean, anything but that. Yeah, Melly's been isolated without family contact or visitation for the last 3 years. That will break most
absolutely.
people. That is torture.
Yes.
Your motion. What else do you want to tell?
I will rest on the motion, other than to say to the court that under the rules, since it's related to the murder case, they are obligated to give it to us. And I think the court ruled that since defense counsel has not been charged or defended in the case, and they've had this information for over a year, and nothing's been done.
Yeah, this is about the iCloud download, because the prosecution wants to say, no, we can't hand it over because that would impact other investigations. They have a defense attorney's full iCloud download. everything, every call she made, every text she made, every video she made, every sound recording she made. They have it all. I mean, that is insanity. That's, and not until the defense found out did the prosecution suggest, oh, we can have this, what do you call it? Torch? No?
Dropped, maybe?
Well,
Or-
a bunch of people looking at it and remove the attorney-client privilege information.
Oh, they have the no cross contamination. I remember when some other lawyers have needed to have things, or I don't remember which case it was, but there was a Dropbox and accidentally some client attorney emails had gotten in to the collective Dropbox for the case.
Yeah. But the prosecution or the investigators have had her iCloud for over a year without telling her. So
Yeah,
I
I don't-
assume they have gone through it all. But they don't want, because if they get everything they have, they will know who accessed it, when did they access it, everything. And the prosecution really don't want that. So, yeah. Malik Parker. Can the defense object to all evidence introduced at trial since the state spied on Liberty's iCloud, including attorney-client privileged info and evidence? They can motion to dismiss with prejudice due to prosecutorial misconduct.
And I would think anything that they try to charge the defense attorney over would be fruit of the poison tree, considering that I don't know how vaguely they had to write this search warrant for them to be. Basically, I want to see the search warrant application. How did they write this to get a judge to agree to invade the iCloud of a defense attorney?
Because sadly, the judge rulings was they had to hand over the search warrant, but they did not have to turn over the affidavits that led to the search warrant. And that is a shame, because they really need to know what was in those affidavits to make a judge rule that a defense attorney's iCloud in its entirety should be handed over. Taint team, thank you, Malik Parker, thank you. Yeah, state said, oh, we have our own taint team, go through the iCloud.
The state seems to be entirely made of taint, but I mean, at this point.
That it does not qualify as an ongoing investigation. In addition to that, that they are obligated and they cannot hide behind the open investigation provision when it deals with information on charges against Mr. Dennis, specifically the murder and the tampering. And they indicated that the tampering case is somewhat going to be used in the murder case, as I think they said, consciousness of guilt. Furthermore, I know the court has told us to talk to Mr. Dennis concerning the potential conflict, and they have alluded to the conflict today. He doesn't know how to make that decision because he doesn't have sufficient information to determine whether or not he wants to keep Miss Liberty or any of us on the case because of this pending, so-called pending investigation. I mean, it's now over a year. It's more like 14 months that they've sat on this information.
So, state, listen, for the most part, I agree with what Mr. Avison just said. You have a continuing obligation, so you do agree anything that comes from any source that is relevant to the charges against Mr. Dennis, you gotta turn that over, right?
Yes, Judge, there's an ongoing obligation for things relevant to his homicide or to his open tampering charge that would be turned over. Having said that, Judge, we weren't noticed for this particular motion today, and we would rather have a full response. The notice says motion to compel we didn't actually receive this with this Liberty's pleadings. This one actually came separately, and we only received it, I think it was 2 days ago.
2/14 it was filed. And
Well,
And I honestly,
Oh no, you only got it 2 days ago. At the same time, your response came in last night.
It is hard to keep up with these mental gymnastics.
Yeah. How many? Oh, let's play the victim card again towards this judge. I'm sure that will go over well.
Yeah.
The world sent it. I would be careless to have trial strategy on private cell phone that the prosecution could have access to it. That is outrageous. Yeah.
Well, but it wasn't the cell phone, it
iCloud
was
is
the cloud.
the cloud. Her iPads, her iMac, or her Apple computer. Everything that was uploaded to the iCloud from all of her devices was allowed to be downloaded. All of it. So,
it says motion to compel. Just look at these files, so many that we were unaware that this was going to be hard.
okay, let me, hold on that. Here's the last paragraph, here's what Mr. Davis said. Affidavits, search warrant, police reports, the name of any witnesses, and all witness statements related to the Apple iCloud account belonging to Raven.
oh, she did write it in the motion. You lied to the judge.
Well, no, he didn't lie. She just has so many motions to compel. He didn't know where he was being compelled from. He had compulsion amnesia.
Yeah, that's it. Very common amongst prosecutors.
Maybe you should just turn over discovery.
Yeah, no, but that's irrelevant. That could destroy their case.
Yeah, it's detrimental to our caseology here.
I want to again watch what
Police reports, the name of any witnesses, and all witness statements related to the Apple iCloud account belonging to Raven. Before I ask you anything, all this stuff belongs to Ms. Liberty, and she asked Apple to just give her a copy.
I believe her lawyer did write a letter asking for the return of all, and they said they were giving nothing.
They're not gonna give her her own thing?
Nothing.
So let me just, if you
You
will,
asked for it and
I
they told
did,
you
I
no?
did actually email, because when they let me know about this one, they give you an email that you can address to them. So I sent them an email, they said, hey, we told you, you have to contact your Broward Sheriff's Office to get anything done. So
So
I
Apple won't give you your own stuff?
they said Broward Sheriff's Office. Apple then did sit with me, I went through it, I have access to the iCloud, but no, they will not give me the return of what they got.
But you have access to the iCloud that has all your stuff on
Of course, that's just my iPhone.
it? In that-
It doesn't matter. They have it in their possession.
Listen,
But what's important here is not, oh, now have your access. That's not the important stuff. The important stuff is what did they do to it?
And what did they look through? What
Yeah.
was considered? I mean, now that the state has subjective, relevancy tests, how are they picking out what is relevant and what's not? I mean, you can say you have your own taint team and things like that, but when we don't know the subjective ruler that you use to rule things, relevant or not relevant, then we don't know what's going on.
I disagree with you, but you all are a little more adroit in these technical matters than I am. There's nothing that's outside of what's in her iCloud, everything's in it.
I don't know. I don't know what they see, because I believe there are additional search warrants based upon the original search warrant.
Well, I don't know anything about that, but as
I
far as the
understand.
search warrant, I already ordered you to get that, you got it. As far as police reports, there isn't any police reports, right?
It's still an open, it's still an open investigation, Judge.
I disagree with that pursuant to Florida statute, but there are no police reports.
There are no police.
Because nothing's happened.
No.
Okay, so there's no police reports. The names of any,
There might not be a finished police report, but there are notes, there are emails, there are conversations about it.
Well, so I guess if it's fair for the goose is fair for the gander, then can we, opt to get the government's iCloud? I mean, we'll find out what's relevant and not, and we'll give you whatever we feel like when we feel like, but we're going to need all of that because they're bypassing work byproduct rules by trying to get these iCloud, and then the judge is missing the point because I don't know the point he's trying to make, like, she has her iCloud back.
Yeah.
I don't know if he's being obtuse about it or he just doesn't understand what's going on.
Yeah, because in a warrant, they get the data behind the iCloud, access to it and everything. So, yeah. Hello, Mr. Jingles. Are you marinating me for the future?
witnesses, and all witness statements related to the Apple iCloud, that would be like a custodian of records, right? There's no other witnesses to iCloud, except a custodian of records.
It would be Apple or the records custodian certification.
Have you listed a custodian of records?
There's nobody, no, Your Honor, we have not listed either the homicide or the tampering case.
So you would have an ongoing obligation to do that, if you wanted to use any of this.
We have an ongoing obligation to turn over anything that's relevant or may be relevant to either of those two cases. We are complying with our discovery obligations at this time.
All right, so affidavit, that would be, a defendant would be entitled to the affidavit, for example, if they wanted to file a Frank's motion, if they wanted to say that this was incorrect and the judge should have signed it. But Mr. Demings doesn't have standing to raise any of that, that would belong to Lisa Liberty, it's her stuff. There's no case involved, so I don't think at this point you tell the affidavit, but listen, this is what I'm gonna do. Go ahead, sir. I'll give you the last.
I find it hard to believe that there are no investigative police reports saying they contacted witness A, witness B to verify or to corroborate whatever is on, whatever they seized, pursuant to their original search. I find that hard to believe that in a year, they come in here and file a motion indicating that Miss Liberty must get off the case because of the conflict. I find that very hard to believe. And I find it hard to believe that they, in their investigation, did not take statements of potential witnesses. And they say it's interrelated to the murder and tampering. So
I mean, they're in a continuing obligation, okay? If we get somewhere down the line and something is put before me that they had material that is required to be disclosed pursuant to 3.220 on February 18th, and sometime long before February 18th, and Mr. Griffith is standing here and telling me otherwise, he's gonna have a very large problem, right? A very large problem. So I'm not playing with it.
I appreciate it.
So at this point, I have to take everything at face value.
Then
But that being said, I'm gonna grant your motion in part as follows. State, I'm gonna give you 20 days to turn over anything that you have received regarding the Apple iCloud and Greater Liberty that you intend to use at either trial, okay? And make it as detailed as you can, because if we get forward to the point of a trial and they stand up and say, Judge, they didn't disclose this and now they're trying to use it, you will not be using it. Because it'll be barred as evidence at trial, okay? So that's 20 days to turn over anything in the Apple iCloud, download that you expect to use at trial in either case, in Mr. Denner's case. All right, and I'm basically ordering you to comply with the rules, which you already should be complying with. So
with that,
it's otherwise, the defendant's motion otherwise respectfully is denied for the reasons that I stated on the record, At this point, there being no arrest and no charges and no case, I don't believe that there are any police reports. I don't believe she's entitled to the affidavit, and outside of records custodian, I don't believe that there's any witnesses or witness statements. But again, if that turns out to be something different somewhere down the line, I'll address that.
What about the affidavits?
I don't think you're entitled to.
If it's not a pending open investigation, and they're alleging certain things that supposedly deal with the tampering and or the murder case, then we're entitled to that.
Well, they, he has to turn that over,
Okay?
whether it's in the affidavit or not, whatever it is. He has to, as it relates to Mr. Demons, he has to turn it over, as if it only solely relates, if Miss Liberty, if they're, I have no idea. If they say Miss Liberty went and did X, Y, Z with witness A, I don't know how that wouldn't be considered as relevant to the case. If they want to introduce that in the trial, then they're gonna have to turn it over within 20 days. So I think you're gonna have your answer
We'll see.
in 20 days.
We'll see what the response is, and I'm sure we'll see.
So let me go back around to number one. Miss Liberty, take your time. I needed the motion to compel that was related to the order that you're now seeking to enforce. This is back on motion number one.
Okay.
Judge Murphy granted a motion to compel on February 9th, 2024. You're telling me the motion to compel that I'm looking at is not the correct motion to compel. So I need to know the motion to compel that you believe Judge Murphy was addressing.
In this, I don't think the judge has much choice because the state is hiding stuff, but there aren't any tangible evidence of what they are hiding. Just that
Well-
they might hide something, and it's hard for a judge to do something about that until the defense brings it up. Hey, what's this?
Now, if the judge allows them to weasel out after this 20 days, then my opinion of him will change.
Yeah.
I haven't had enough contact with this case and this judge to be able to say, okay, well, he's going to kind of do a Judge Goal thing where he basically just rubber stamps whatever they say and negate the defense. So I don't know his track record for really holding either side's feet to the fire, but I guess in 20 days, if we come back and he allows the state to have another continuance, then I'll kind of know that measure of him. But it does seem like he can't accuse the state without having any guidelines with which in actual concrete evidence. So by giving them this 20 days, it does seem like kicking it down the, road. So like I said, I'll have to wait and look back at 20 days. But it does seem like he's giving the defense some things that say, okay, if they don't do that, come back here and I will be, a hard ass with them. So I do hope that he, keeps his word and holds them to that. But if he doesn't, I'm not going to be shocked either.
Yeah, I mean, we've seen too many judges go back who sound much, but doesn't do much. So we just have to, but again, he's giving them something, and that can lead to something else. So if, for instance, if we are back here in 20 days and the defense says, Judge, they didn't. Yeah. Hey, I got a new member, Idiot Wind. Hello.
Sounds like a great punk band. Like tonight, playing from Denver, Idiot Wind.
Yeah, I was just about to say she has to be from Denver. Welcome to the Viking crew. Oh, Viking Raider. Hey, nice. Thank you. That's the $5.
Ooh.
I have a $3 and a $5. There's no difference between them. It's just if you can and think it's worth it, then go right ahead. Because I can't figure it out because I'm as technological incompetent as this judge.
Well, at least we feel seen.
Yeah. But thank you so much. Thank you so much. All right.
I thought Abe Vigoda had died.
The who, the what?
Abe Vigoda, he was, I think, in The Godfather. He was kind of old even when I was a young kid, but then he became steadily more decrepit and older.
Some people are just born up. Have you seen pictures of the Seventh Seal, the Ingmar Bergman movie? You know, when he meets death, the knight who meets death.
No, I
Where's
don't
Son
think I
Zero?
have.
Oh, hold on. Let's see here.
Okay, I'm glad that the chat is agreeing because I have these thoughts. Like the new trial that I'm looking at, the judge looks exactly like Boss Nash from Star Wars. And I don't mean that in a mean way. Oh my God, it's him.
Yeah. Yeah. Max von Sydow, who is in the foreground here, well, he was 27 when he made that movie.
Oh, wow.
Yeah. He passed away a few years ago at 90 something. So yeah, some people are just born looking old. Seven Seal was made in 1957. Jesus Christ. That was a bit ago.
The only Seven Seal I saw had Demi Moore in it, so not the same movie.
No, not that movie. This is the very drawn out, poetic Ingmar Bergman movie, who is supposedly is one of the best movies ever made. I fall asleep every time I try to see it.
You get to see Demi Moore pregnant and naked in a bathtub in mine, so
Yeah.
pros, cons.
Potato, swings and barrels, or whatever it is. Yeah, Benjamin Button, but never got younger. Yeah, that's darn it. Oh,
So Judge, the filing number of the motion,
In which case number?
23.
In the 23 case number. What docket entry?
So 70 and 71 would be the orders, those docket entries, and then I'll give you the filing number,
What is the date?
February 9th.
Judge Murphy signed an order
2 orders.
February the 7th.
Yes, he did. Excuse me, no, Judge, I filed the motions the 7th, right? He filed orders on the 9th, the docket entry 70 and 71. They then, I believe, filed motions for rehearing, and then he filed additional orders saying,
Wait, what date did you, the motion to compel?
the motion
That he's ruling out, what date did you file that?
February 7th, 2 of them.
it seems like the docket isn't in order as well.
Do they not have interns?
Apparently not. They are hiring everybody as assistant district attorneys.
Ooh, I have a shot. Fonnie Willis.
You really want to work for Fonnie Willis?
No, I want to take her job.
So they filed their motions for hearing on February 13th. That's what it is.
You're talking about the motion that's filed February 7th, 2024, asking for, it's the same thing you quoted in the pending motion. Proof of all efforts made by law enforcement to serve Mariah Hamilton. And then number 2, email dated April 18, 2023, And then number 3, any and all emails between the state attorney's office and Christopher Barris to arrange Mariah Hamilton's appearance at deposition, correct?
Yes, Judge.
And you're telling me the state has not just complied with this order, they have not disclosed those items to you?
No, they did comply. They gave sorry, I didn't ever get the 218. I didn't ever get that clarified until we did the deposition at Garrett Steele and he brought them. The subpoenas, I had got an outdated subpoena, which looked to me to be an out-of-country warrant that was good for 90 days, that was issued sometime in 2020. I was looking for something that would have put her on notice of Mr. Demon's trial date that we had already conducted and for any depositions. I had asked for any attempts to locate her. I had reason to believe Ms. Hamilton had actually graduated from college and walked across the stage, yet they can't find her. So I was just asking for whatever efforts were put there. They moved for a rehearing, that was also denied a year later. If they don't have the items, as I put in my motion, file a response that we don't have these items in our possession or they don't exist. I am literally trying to box them into a statute that I, again, don't think they've met. It's vindictive, but I will take the steps to prove that if I have to.
So you're talking about you need paragraph 1, proof of all efforts by law enforcement agencies to serve Mariah Hamilton with writ to appear at trial, including not only skip traces, searches for employers, searches for enrollment in college, trade schools, or other education. All efforts made between the state attorney's office and Christopher Barris. Who is Christopher Barris?
He represents Ms. Holmes as well as Ms. Hamilton.
He's a lawyer.
He's a lawyer.
Okay, well, regardless of what I think of this motion, Judge Murphy granted it, so don't you have to turn this into?
Judge, we have, and SIG also filed a response on February 9th, 2025. When the court received it.
So,
February 9th, 2025, in which case number?
It was filed with.
so let's see here. She filed this with the previous judge to compel them, and they didn't bother to reply until 2 weeks ago.
Okay, in defense of those of us who haven't finished our book report yet, it is not our fault. Our dog ate it, and we will get it in after a continuance.
Oh, thank you, Idiot Wind. Oh, 20 pounds. Oh, so you're not from Denver. You're from somewhere in the UK. Well, that also applies to Idiot Wind. It says, just want to thank you. You have such a keen eye for legal identifying issues that far too many take for granted, and a unique way wading through them with humor and clarity. Aw, thank you.
Oh,
I do my best, and thank you so much for your 20 pounds. That's like, I don't know, $50.
I know.
Oh, yeah, I do my best, but most of, especially now in the YNW Melly case, I'm throwing things from my hip. Is that an expression? It is now.
Shooting from the hip.
Shooting from the hip. Okay. Now I'm not allowed to own a gun, so I'm throwing things instead.
It does make sense. It's the Swedish toss. That's what you're well known for around here. It's the old Swedish heave ho from the hip. That's it. When you come back to America, we're going axe throwing. Can you imagine? First, it was two cripples trying to walk. Now it'll be two cripples trying to throw an axe. It'll be great.
Well, I'm good with axe, but I throwing it that seems unnecessary because if I miss, I don't get it back.
It just seems like something that they looked at me before requiring signatures and like waivers. Because when I was like, so when do I release the axe? They were like, and you sign a waiver.
Let's have nobody directly in front of me, nobody directly behind me, just in case. Whoopsie. And just in case, just don't
I
be
was the
around
only
me.
one that had training wheels on my axe for some reason, like it was just a Nerf one. Maybe I was profiled on the way in there. They were like, "Redhead, you get the Nerf axe. We are not giving you anything with a, blade on it."
Fenris Tobin's toss from the hip. I'm officially using that now. Yeah, you're welcome. Welcome to the Nick Starro Trial Watch show, where you get completely new expressions to use.
Yes.
It was filed yesterday, I'm sorry, the date on the notice says February 9th. It was filed yesterday.
Oh, they filed it yesterday. Oh. But Your Honor, we did file a response yesterday.
Hey, it's the best kind of true for a lawyer, which is technically truthful.
Yeah.
And I appreciate it. Like, look, lawyer, at 11:59.59 last night, we did in fact execute a, response.
Yeah. But, Your Honor, we have replied. Oh, really? When? The February 9th. Oh, I'm sorry, yesterday. Oh, wow.
File meeting number 19-1872 CFNA.
So I didn't receive it, Judge. Is the matter, I was up
Yeah,
this
I haven't
morning
seen you.
checking my emails.
So you want me to pause on this one since all these filings are just coming in, and in the interim, maybe you all can kind of resolve this between yourselves. It doesn't seem very complicated.
It's not, but
It's not, but.
So Ms. Liberty, you want to take this one pending? I'll defer on it. I'll take no action today. It'll remain pending for our next hearing on all pending motions. You want to do it that way?
Yes, Judge, fair enough.
Okay, so that's all the matters that were noticed for today. I'll sign all the orders momentarily. State, anything else that you need me to do regarding Mr. Zeman's? I don't know what you're saying on it.
do you want to address Friday's hearing before we have a moment though?
Sorry, to see it. What's that?
Mr. Barris set a hearing for Ms. Hamilton this Friday. Unfortunately, Ms. Buffalo is out, Ms. Collins is out, and I have a conflict, so we were just gonna ask if the court would set for next Friday.
What is this? Under emergency motion?
The emergency motion for monitoring. We just have a conflict. Your JA said it without,
You object, right?
yes.
Okay, I got it. State object. So just, your request respectfully, I just have someone here. I'm well aware of the state's position. You object. State, anything else?
Nothing today, Your Honor.
Okay. Defense, anything else you need me to do for Mr. Demets today?
Your Honor, if I may,
Sure.
I'm a great fan of motions and limits. And I've been practicing way too long, my wife tells me. Every judge I've been in front of handles them differently. And all I'm asking from the court is, how do you handle it? I file motions in limine before the trial, not only because, I should say, always knowing that whatever the ruling is on a motion in limine, it can change because of what happens during the trial. And it may open the door to something that had been in motion in limine, had been told that it can't come in. So I understand that. So one of the purposes of the motion in limine is also so that nothing is said in opening statement to the jurors, so that in case this evidence does not come in, they have not been prejudiced because they've now heard an opening statement. You're going to hear A, B, and C, and then when the time of trial comes up and the testimony is objected to and it doesn't come in, and therefore we have a mistrial, we have comments supporting the evidence. So all I'm asking the court is, do you not want to hear any of the motions in limine until the time of trial when the evidence is coming in? Or can we do it pre-jury selection and get a preliminary ruling from the court where your rulings would be, it's not coming in or it is coming in, always subject to what the testimony may be?
I don't have any policy, okay, on these specific things. File whatever you want. I'm happy to give you a hearing on whatever you want, but, my experience is that most of these motions are based on here's what the lawyers think the witnesses are going to say when they come to court. And the only thing that is consistent in every trial is Whatever the lawyers think the witnesses are gonna say when they come in here in court, it's not what they say.
No,
So, I don't know.
I'm talking more of a situation where the state wants to bring in evidence of what happened during the Civil War. just
I'm liking
concerned about
Judge
that. I'm
Bankman.
just saying that
Yeah.
it has no bearing on the trial whatsoever. But they, for some reason, want to bring in what happened at the Battle of Antietam. That would be
Well, I
something-
would find that to be not right.
And that would be something that would be subject to a motion in limine. We would have to wait until the middle of trial, because that would be something that the court on its own prior to trial could make that ruling. So that's what I'm saying. I'm asking on things like that where we're not waiting to see whether the door is open. Can we file those motions?
Sure. File whatever you want. I think best practice would probably be you all talk to each other about it.
Is that like a woman, like, do whatever you want? You know, like, fine, do what you want. That sounds like one of those,
Yeah,
like,
and
challenge.
yeah, and for you guys out there who haven't experienced that, do not do what you want. No,
It will
it's
not be okay.
No. I'm going to meet with my friends. You do what you want. Oh crap.
No, honey, I'd much rather have a long, uncomfortable talk about our relationship right now.
Yes, honey, I really like these romantic movies. Let's watch the piano one more time.
No, I have deep and personal feelings about the Blake Lively, Justin, what's his face thing. You don't even know his name? No, I don't care.
What's his name? Bill, the comedian. He does a thing about that.
Oh.
Men and women. Men are basic. Women
Yes.
are kind of, you want to know more. And
Yes.
he did this skit about he was at the gym and with his friend Frank, and his friend Frank said, "Hey, I'm getting a divorce." "Oh, that's too bad. Can you spot me?" Then he came home to his wife and said, "Hey, Frank's getting a divorce." "Oh, what happened?" "I don't know." Did you cheat? "I don't know."
I don't know.
You don't know
He look, he benched 25 or like 150. I don't know.
Yeah.
A lot of
I
resolution.
guess that's not how things are gonna go. So, yeah, file whatever you need and I'll set it for you. And I'll give you hearings on it. Defense, anything else I can do for you?
I have an odd request, but
Yes,
if you would entertain me,
Yes,
because
ma'am.
it's out of the box, but in light of these allegations that I'm, I guess, trying to murder or take a hit out on Danny Polo, it's came to my attention that Danny Polo might be suffering from some type of mental illness at this point. We heard in the last trial, he thought somebody had a hit out on him. He applied to the court, we found out he had pictures out there in the public domain. And now, 2 years later, I'm being accused of trying to kill Danny Polo. I don't know exactly, I don't know the affidavits, but it's a homicide, it's inactive, and it's Danny Polo's picture, and I'm directing gang activity. I think at this point, Mr. Polo is in need of an evaluation to determine if he even has the capacity to sit and testify in this case or any other case, because he has some type of paranoia about being murdered at this point. That's where he's going at a defense attorney, saying a defense attorney is trying to murder him now. Because that is the premise of this so-called investigation, is I'm trying to kill Danny Polo. That's the witness that they're saying I'm tampering with, because he was impeached, not once, but twice.
Okay, the request is,
That he undergoes a psych evaluation before he's allowed to testify further in this case.
I think, because I don't entertain or entertain motions, but I think you're talking about challenging the competency of the witness, correct?
Yes.
Okay, so I think if you have that concern, I guess you need to file the appropriate written motion regarding the competency of the witness, and then I will give you.
Thank you, Judge.
Okay, anything else?
Yeah, so this former undercover cop with a baklava. He had to reveal his face on the stand, and now apparently he's claiming emotional distress, which the prosecution and the investigators translates into witness tampering. And that is how they got her iCloud. The mental gymnastics here. I mean, I've seen what was it called, contortionists, less flexible than this prosecution.
So, by that logic, any Google search that I look up of any famous person or even just random local person is considered harassment.
Yes.
There,
Yeah, but
well, because it's starting with the premise that there is no reason under which, through any sort of mechanism, she would have run across his photo unless it was for nefarious reasons. Not him putting himself out there as a gang expert from, what is it, Dubuque, Iowa, or whatever it was. Like Vermont, the place that has, negative diversity. I can't remember where he said, but he's like, look, the first time I saw a gang member was when I went to Chicago or something. It was...
Speaking of diversity, did you know that Delphi, Indiana has a 97% pure white population?
Having lived in Indiana since the age of 4, can confirm, not too shocked.
Yeah. So statistically, if you considering the murders in and around Delphi, Indiana, you more or less have a 50-50 chance of surviving.
Well,
with a floor of 4. Because
that is true.
With a population of 8 black people, yeah.
That one is something I am trying to look more into. I do have, 6 children, so my time is somewhat less limited, but living in this state, it really is a stain that we can't get some answers. Those were beautiful young girls and young children, and their family, the state needs answers. I want answers.
Yeah, I have a lot of documents. I can send it over to you. Or give you the link to the Dropbox, whatever it was, because I got everything sent to me. So I have read through it, and for me, it is absolutely bonkers that the landlord hasn't been charged. For me, it's more or less a slam shot case.
It is becoming more and more terrifying that in my own backyard, there is not an expectation that we can receive justice for, children.
Oh, by the way, that landlord is also a member of the local Delphi
Masonic Lodge?
Yeah.
At this point, why don't we just call that the Manson family? Only we can call it the Mason family?
Yeah.
One excellent.
Yes.
Ms. Buckaloo is requesting court previously entered an order about including these cases she didn't heard on Zoom. Ms. Buckaloo is asking if you would expand that order a little to allow her only to appear on Zoom.
I would be happy to allow all the lawyers to appear on Zoom, based on what happened.
What I think
I would need to know, because all of your names are out there in the public domain.
She's just asking for Friday, for the hearing of Mr. Barris as to.
Sure.
Mariah Hamilton motion.
But even going forward, the court can limit people who come in and only just allow her in, forbid everybody else from coming in.
I completely agree with you, but based on the creative nature of the viewing public out there, if I get 7 or 8 or 9 people that all sign in on the same name, then I'm not quite sure how you want me to handle it.
Well, we can verify which account Ms. Buckaloo actually is.
I would.
Well, if their name is Mike Hunt, I'm pretty sure it's a joke.
I to do that. I entered the order that I entered because of the reasons that I put in the order.
No,
It's the only case I've ever had to do with.
right. And it's the only reason we're asking now. We were fine appearing in person, but obviously with
No problem.
our ongoing issues.
Maybe off the record, like the parties want to talk to each other and agree to each other on some code names that you want to use, and only you all will know that. Then I'll let those names in, to the Zoom meeting and that'll be it. But that will require you all to talk to each other and agree on something. So maybe we can move the wheels on the wagon.
There's a lot of
The
talk.
weekly payoff.
Okay, understood. All right, so, Mr. Nemitz will remain set for trial.
This is from
September the
Luigi.
10th at 9 o'clock. It sounds like I will see all of you next Friday, or a couple Fridays down the line, March 7th. Or is it next Friday or this Friday?
This Friday is
This Friday,
Mr.
regarding Ms. Hamilton's motion. Do you all want me to let me ask you first, do you want me to set another hearing for all three motions at some point?
The ones that we have, we're not prepared to go forward on this time set now.
There's nothing else you need to do?
No.
Ms. Liberty or anyone else on behalf of the defense, besides the one that I'm holding in abeyance right now that I'll have to set at some point, you want me to give you a date to hear that and any other motions that I can hear at that time?
Let's just take a date, and if we need to cancel it, we can cancel it, but I'd rather have a date than not have a date. Everybody's giving me dirty looks.
How about Tuesday, April 1st? Tuesday, April 1st.
I am supposed to be in trial, but I expect that case to resolve.
I believe I have a child, Your Honor.
I
I have high
don't
hopes.
see any
If not, you'll be,
non-crime
I'll be
thing.
here, but I believe we'll still be in that trial, yes.
defense, April 1st, 8:45.
No,
That's fine, Your Honor.
Okay,
In addition,
That's,
on this Friday, the
April 1st. That checks out.
emergency,
I'm sorry to interrupt. I'm sorry, Judge. I'm actually, if we do it that morning, I would not be able to start probably until like 10:30. I had to change it to that morning, but Judge Diamante's, I have about 12 victims coming in on that.
you want to do it at 1:45? I'm still in Ms. Collins' trial. The lunch break is from 12:30 to 1:45.
That's fine, we'll take 1:45.
1:45 PM on Tuesday, April 1st.
perfect day.
Yeah.
In addition, this Friday on the Hamilton motion, Mr. Dennis requests.
Yeah, he'll be on the document. He'll be here.
Oh.
Thank you.
Okay, so I guess I'll see all of you this Friday, which is Friday, February the 21st, at 8:45 AM. Again, this trial remains set. September the 10th.
Has it already happened?
Thanks, Judge, thanks for your patience. Ms. Wilcox, is that otherwise include the FT doc? Oh, what for the fee hearing? So actually, it'll be in recess until 3:30 PM this afternoon. Madam Court Reporter, I do not see a court reporter.
Can't see any.
Oh, right.
I can't see anything on YouTube.
Now, was the delay for this trial because of the COOF? Was it because of all of these ancillary things, or?
The first trial ended in a mistrial.
Okay.
So this is the
that-
retrial.
All
And,
right.
that should have already started, but it's not. Yeah, because prior judge retired, and now the new judge, so everything got a bit postponed.
Okay. It does seem very odd that a state's witness can make wild accusations. And, you know, she is probably right. It probably is snarky. But if his general default is everyone's trying to take a hit out on me, then he's not an objective, gauge as to whether there really are dangers going on in his life.
Sorry, I was just checking. I see references to YNW Melly screams at ex-girlfriend snitching in court, but I don't think that's hearing has.
I felt the exact same way. I was trying to look at the new stuff on the Delphi things, but you and EU got it earlier because your day start or your time.
Yeah. I don't see anything in that this actually happened. So but I don't see. Dun, dun, dun. Nice. Seems like it's just clickbait. Yeah. All right. That was that with this. Now, let's go into what has transpired in the Delphi case with
Yeah.
allegedly burner phones being at both the crime scene at the murders of Abby and Libby and the 2012 abduction of, what's their names again?
Elisabeth Collins and Lyric Cook. So I had
Yeah.
not been familiar with this case, and I do know that Max, HBO Max, or whatever HBO and Cinemax made, has a 3-part docu-series on the Evansdale, Iowa murders. So I will be looking into those because, like I said, I hadn't heard of this, but this raises a whole lot of questions, but it also goes back to my theory. And I don't know if you remembered when we first started looking at this case, I said that this case reminded me of the West Memphis 3. But I wonder if police start looking at cases of abductions of multiple children that were also close to, freeways, highways, major transportation, highways in America.
Yeah, because these two events is roughly 240 miles apart. If you draw, say okay, say these are the two extremes, then you draw a big circle and look at abductions, disappearance, murders of minor girls, and see, okay, what do we know? Because
And
this is a coincidence of coincidences that two burner phones were at the site of the abduction of two girls.
well, and it's eerily similar. So these two young girls in Iowa were last seen riding bicycles in a popular recreation area in the middle of town when they disappeared on July 13th. So 13th, and then we've got 13th of February. Now, again, I could be just straw manning, a bunch of things, but that's correlative to me. But also, they were in the middle of the heart of a town where you wouldn't think two children would go missing. Now, another thing that is very reminiscent is that they were later, both bodies were found in a remote wooded wildlife area.
Yeah.
And their cause of death has not been released either. So we don't even know how these two passed away.
Yeah.
It looks like their investigators are also playing very close to the chest.
Yeah, but on its face, it's eerily similar. And I've seen the discussion on X and otherwise, people who are starting to, okay, girls murdered who roughly resemble each other. And then it's a lot. I saw a case from starting 1998 up until 2017, and there's a lot. And just where were Ron Logan in 2012?
Well, it seems like
yeah.
the more stuff that comes out, it looks like the Odinist theory doesn't need to be exclusive.
Yeah.
So it looks like this was an amalgamation of both diaper buttholes, like you call them, and gross people who like children too much.
Yeah.
It seems like an unholy alliance of, well, just the dregs of humanity.
Yeah. And all of a sudden we are getting substantial evidence of people sharing images of minors. And remember, folks, there's nothing of that in the history of Richard Allen's, nothing of it. But it is in other persons of interest in this investigation.
Yeah, and this could absolutely, smoke, but there's not fire. But the fact that we are being actively told we can't see public, exhibits, that we don't need to preserve evidence, that we don't need hearings on any of this stuff.
Yeah,
It just
I mean,
breeds that ground.
It could be a nothing burger. It absolutely could. But we don't know. And now we are starting to find out stuff that nobody knew about. But I
Yeah.
do remember, for instance, there's been rumors about people sharing illicit photos of minors floating around. But since there haven't been actual evidence presented of it, it's hard to put that into a factor. But now it starts to trickle out. And once the appeal, once they have all of it, once it's out of Judge Gull's hands, I do believe the media, especially for Vinny here, he's not letting this one go, and I applaud him for it.
I applaud him. I just wish it hadn't taken so long. I wish he
Yeah.
hadn't been such a scoffer, like, oh, Odinist, okay. Didn't even read the motion, and now that he has, and he's talked to other people, it's like he needed another lawyer that he respects to read it and then say, no, this looks like some good stuff, before he would take the time to be independently curious.
Yeah, but better late than never. We all wish.
True.
Because this is and according to other information, the people in Iowa who investigated asked, these are too similar. Please, let's cooperate. And the answer was more or less no.
Yeah, I think from what I'm looking at it, Carroll County was the one that told them, or at least how it was written. Indiana, compared notes, but told them that they have no reason to be connected. The way they have the sentence structured, it looks like the Indiana State Police were telling the Iowa investigators, look, we've looked through it and we don't see any connections.
And it seems like...
Well, we have Stevie Wonder, the sighted piano player from, of Desk Concerto No. 3, McClelland, and Holman, who thinks all the sketches look like Richard Allen. So I'm not taking anything that this brain trust tells me as an Iowa investigator, but...
Yeah, but let's go through Vinny's segment here. It's 43 minutes. I'm joining the... let's see here. The laid-back law today. I'm going to talk about these new revelations about the Delphi case over there as well.
Oh,
so,
cool.
But let's go through this first. Oh, good sound.
We get so confused by it.
I'm Vinny Politan. The subject of my investigation is the Delphi murders. 2 innocent young girls brutally killed in the middle of the day in Indiana. Their killer has been convicted. But many are questioning the verdict, the trial, and the judge. Here's the story. For more than 5 years, it was a mystery. An unsolved case with many leads, suspicious characters, and so many rumors. Investigators released very little information, but journalists, podcasters, and true crime followers all speculated on what happened to best friends Abby Williams and Libby German, two teenage girls living in the small rural community of Delphi, Indiana, a town with just 3,000 residents. On February 13th, 2017, the girls had a day off from school, and they decided to go on an outdoor adventure. They were dropped off near the Monon High Bridge, and that's where their bodies were found the next day, on the property of this man, Ron Logan, who was questioned by investigators and lied about where he was. But Logan was never charged with the murders. Then, a man named Keegan Klein became part of the investigation because of a fake Instagram account. He was arrested on child pornography charges. Then, finally, 5 years later, Richard Allen was arrested for the murders, someone no one had on their radar. At trial, he was quickly convicted by the jury based upon many of his own alleged statements. Allen still claims his innocence, and his attorneys are still fighting for a new trial. There are very few cases where you have a brutal murder like this and someone is convicted and afterwards people are like, well, wait a minute, not so fast.
Not afterwards. We have been shouting from the damn rooftop for years about this. But
Yeah.
at least media is on it now.
You know what?
And
I'll take
yeah,
I'll take it.
I'll take it. Yeah, definitely.
I mean, because honestly, I don't always get the, details right all the time, but with his voice and his backing behind,
Yeah.
some of these things, then we can get the best and the brightest out there
Yeah.
and get all of these disparate pieces of information, because it's really not about the information that we have. It's about these independent sleuths, finding this and that and the other thing. And if we can bring it all together, because I think that this introduction of the burner phones brings in suspects that I think that just looking at the Odinist or looking at the, Jordan Schatz kind of disparate leads, I think it amalgamates them into something that could be a singular lead. And instead of excluding Keegan Klein, you bring him in, and it just, I think, is a new direction that should have been looked at prior to.
Yeah.
And that's what's happening in this case for many, many reasons. Lack of transparency is a big part of it, but there are other reasons. So Richard Allen, the convicted killer, his attorneys are fighting this, and they're continuing to litigate this case. They believe they are going to get a new trial, so they're trying to do everything they can in the meantime to make sure the evidence they need at this new trial is still there. One of the things they've done is file a motion to preserve evidence. I want you to take a look at what's in this, because when they filed the motion, they're revealing sort of a little bit of insight.
And Judge Gong denied it without a hearing. The corrector preserve evidence because, it's too vague. No, it wasn't.
Yeah, no, it wasn't. They were almost pedantic in what they wanted, from timestamps to, actually itemizing different things.
Into what evidence is out there and what they believe they can put out there to prove their case. Take a look. It begins here, a motion to preserve evidence. He, Ricky Davis, talked with Ron Logan about the Delphi murders on multiple occasions over the course of time. Logan confessed to his involvement in the murders along with two other people. Ricky Davis is an inmate with Ron Logan. Keegan Klein was placed in the same general area as Ricky Davis, and at some point apparently learned that Ricky Davis had talked to Ron Logan. Keegan Klein began to reveal information about the Delphi murders that corroborated details that Ron Logan had revealed to Ricky Davis several years earlier. Kagan Klein further revealed to Ricky Davis that he and Logan knew each other through the sharing of child pornography that they shared on burner phones, and that further they, Klein and Logan, would see each other every 3 to 6 months so that Klein could assist Logan with using the burner phones because Logan was inept at working with electronic devices. This is absolutely jaw-dropping.
Yeah. Now, what was rumors is now on paper.
Well, and now we have links. We didn't have a link between Ron Logan and Keegan Klein. And if you remember, Keegan Klein was also arrested with his father. So what we didn't ever have was sort of where Ron Logan
Fit into all of this.
fit in all to this. And this makes it so much more compelling because Keegan Klein really wasn't someone that anyone knew about until this whole, catfishing Instagram thing kind of came out. So, or Snapchat. I mix them up, but wherever this Jordan Schatz was, we never had a kind of understanding as to where this fitted in with everything. Yeah. But this looks so much more devious, so much less of a random catfish. If you've got Ron Logan, who's like, hey, I know these two girls, maybe he sees them, then gives Keegan Klein the information. Again, this is all speculation, but
yeah.
How do we,
maybe
this
pure speculation. The plan was not to kill them at his property. It just happened, maybe without Ron Logan's, or it was too late to do anything, and something happened. We don't, but now we have this nexus that Judge Gold claims doesn't exist.
Well,
and not
and
only one, we have so many nexuses in this, it's starting to get ridiculous.
Well, and the trial did not explain how, with all the nexuses that they had, why the state decided that Richard Allen, with a dearth of physical evidence that links him to the crime scene, how he was the one that they picked, how he was the one that all signs were pointing to him, because that doesn't make sense. If you have people with greater nexuses or greater, signs that point to involvement, what was it about Richard Allen that said, no, we're going to ignore all of this inculpatory evidence staring us into the face and look at this guy?
Yeah. And we are going to get to it as well, but apparently the prosecution knew about all of this before the trial and apparently didn't hand it over.
These allegations or these purported pieces of evidence, which brings us to the first question in our investigation. This is important. About these two guys, is there any connection between Ron Logan and Keegan Klein? Ron Logan on the radar early on in all of this, and then in the midst of the unsolved case, Keegan Klein was put on the radar by investigators because of the child pornography and this Instagram account that he was running. So, to answer that, joining me here in studio, Court TV senior producer. She is an expert on this case and has covered it from the beginning, has some amazing exclusive interviews that she's done. Barbara McDonald, and a private investigator who is close to Richard Allen's family, founder of Victim News Online, Erica Morse. Okay. Let me begin with you, Barbara. What did Keegan Klein say when you asked him about Ron Logan?
So I talked to Keegan shortly after his name was brought out in this case because of the Anthony Schatz catfish profile. He was in jail and he had not yet had his case go through the judicial process. But I talked to him about the Delphi murders and I asked him about Ron Logan. Here's a little bit of that. Can I ask you, do you know who Ron Logan is?
No, I don't.
Ron Logan is the property owner where the girls' bodies were found out by the bridge.
Oh, okay.
Do you know if your father knows him?
I have no clue.
Okay.
I've never heard that name before.
Now, I don't have any way of knowing if everything that Kegan said to me was true in that interview. I do feel like a lot of his statements were true, and he seemed to be answering honestly there, but I don't know.
The only thing that surprised me that a lot of people talk, and this was the biggest case in that area, and he lives in that general area, and people were talking about Ron Logan, I think for years it was his property.
Yeah.
But okay.
And Ron had done a bunch of interviews and
Right.
yeah.
He was very public about it. Erica Morse, is there some sort of a connection here between Ron Logan and Kegan Kline?
Well, if you're to believe Reese Davis, there is. And I'm furious that we're just now finding out about these letters. We'll talk about that more, I'm sure. But let's not forget, Vinny, that further down in that document, there is a reference to a third person. And I am going to assert that the Frank's memo still has a lot of merit in this discussion and in this case, because Kegan Kline is now a convicted man of CSAM materials. You have Ron Logan's ex-girlfriend referring to him as a sexual sadist. You have many of us who have done fact-finding on this case having been adamant that Ron Logan's interest in this case, his interest in talking with reporters from minute one was suspicious, along with Kegan's involvement speaking with the girls prior to the murders, and then all of a sudden we're supposed to expect that these two never connected in this very small town when the rumors say otherwise.
Yeah. First of all, hello, Megan Fox, the raid. Hey, Megan. Oh,
Hello.
welcome to the Foster Club. That is the Delphi case, with the revelation that two burner phones that through geofencing or tower dump, I don't know which one, that was spotted on the scene of the murders of Abby and Libby, also were at the scene of the abduction of a 2012 double murder.
Yes. And that was from Iowa, and that was near Evansdale, Iowa. Two young girls, 8-year-old Elisabeth and 10-year-old Lyric. They were cousins, both riding around their bikes near a popular recreational area. Their disappearance was on July 13th, 2012. Abby and Libby happened February 13th, 2017. So there's a 5-year difference in between there. These two girls in Iowa were also found in a wooded area. Now, we do not know how the two girls in Iowa were unalived because that information has never been released. However, investigators involved in the Iowa double homicide did reach out to Indiana State Police, and the way it's written, the way the sentence is structured in the article, it does appear that Indiana State Police basically told Iowa that there was nothing to see here. Look, it looks coincidental, but there is no links. Do not worry about it. And that's kind of what we know. I will be digging into the Iowa case, but I just learned about this last night, so my powers aren't that great.
This here is brand new information. And the nexus here is that Kegan Kline and Ron Logan, who were early suspects in the murders of Abby and Libby, shared PDF material with each other on burner phones. And all of a sudden, you have burner phones on 2 murder sites. Murders of two murder sites, 2 minor girls. So 4 minor girls murdered. Same burner phones in the area.
And I do like that this investigator is bringing up kind of what I said, that I don't think it has to be an either or thing. I think that, now, Nicholas, follow me on this logic tree, but any of these jerk faces who are in Delphi, Indiana, believing that they commune with Odin may or may not also have deviant, proclivities.
Well, these diaper Nazis are depraved people. Dangerous, stupid, depraved people. I would not put it out of the realm of possibilities that they are also very interested in young girls.
Yeah, so I don't think that this is a diverging of suspects. I think that this is a widening of kind of the criteria by which they link together. I don't think that maybe, and I bet if we looked at some of these people's internet histories and backgrounds, we're going to find some not so savory things going on there.
Yeah, because sometimes you have to broaden the net in order to find the connections between a few people. And here, apparently, we have the connection now between Keegan Klein, the convicted PDF file, and Ron Logan, whose property Abby and Libby was found at. So now all of a sudden, now of course you have to believe an inmate to get there, but
didn't he didn't ask for any concessions on his sentence? He didn't.
No, nothing. No.
So
asking, can I testify? No, reaching out, can I get a lenience? Nothing. He shared this information with the prosecution before trial, and they never related to the defense.
Well, and let's be real. Sometimes these gross people are not going to confess to, their local priest. You had the same thing in the toolbox murders out in California. One of these gross guys, when he was, taken in, but his partner wasn't, decided to brag to, a fellow inmate thinking that he'd be A-okay with the grossness that he was confessing to. And I think the other inmate was in for like double homicide. And he's like, look, I'm a bad person, but these guys are gross. So again, you might not always get the best, these guys aren't going to confess to the guy at the local safe, lot. They're going to confess to other people that are in the same level of grossness. Or at least who they presume to be in the same level of grossness.
All right, let's continue here.
And so does this inmate. Now, let me put this up on the screen. This is again from another defense filing. There was a previous tip relative to Ron Logan, and this goes back to 5/15/2017. So just after the murders, within months, contacted the FBI public access line to report a tip on the Delphi homicide. Logan confessed to Reese or Ricky a step-by-step of killing the 2 girls. Logan told Reese how he burned his clothes in a fire pit and where it was located, used box cutters and struggled with one of the girls, and thought drops of blood from his nose ended up on their clothes.
And we now know that the state medical examiner believed box cutters were used on the girls. And we know there are unknown male DNA on the girls.
Also, it does indicate a prior either involvement or knowledge of the girls to know which one was older. Again, because, you could have said, of all the descriptives that really differentiate, Abby and Libby, that's not a visual cue. So that would be someone that has intimate knowledge with both their history and kind of a familiarity with both of the children. Because you could say, oh, well, you know, the taller one or the shorter one. It just, that kind of distinction struck me as more of a familial, or I know about these kids, than just something you would pick up visually, like, oh, I saw two really cute girls, you know, walking on the bridge. You're not going to know who's older unless you ask them.
And all of a sudden you have, because here all of a sudden you have Keegan Klein who communicated with them,
Yes.
setting up the meeting on the bridge that the day they were abducted. And then all of a sudden you have Ron Logan here who lied about his alibi for that day.
And inserted himself into the investigation readily.
How were these two out of prison? Well, Ron Logan, I believe he was released in 2011 and then went back into prison in 20... just a few... He was charged with something and then he went to prison just a month or so after the murders of Abby and Libby.
Yeah, he was on like the tail end of probation, and I think he violated his probation by lying about his whereabouts. There's a lot of twists and turns in this case, and even something as easy as trying to figure out what Ron Logan was doing, it's buried under a lot. You have to know where to look, and it's also not connected to this case, so...
Yeah,
in the States kind of reckoning.
Keegan Klein, I believe he was sentenced to like 80 years in prison for a lot of PDFing.
And his father.
And his father, yeah.
Reese also advised that he killed the older girl first. Not him, but Ron Logan confessing to him that he killed the older girl first. Now, Barbara, you interviewed Ron Logan as well. What is he saying about all this?
That's right. I spent about 4 months talking to him weekly in the months leading up to his death in January of 2022. And he talked a lot about how his attorney and his son told him in the days and weeks after the murders that his mouth was going to get him arrested for double murder. Here's some of that.
I conclude that, you know, all this that happened to me was my fault. But in fact, I only had 4 weeks to go on my probation, and it was a non-issue thing. In other words, I was done. If they'd have waited a few more days, you know, or another month or whatever before they got themselves killed, nothing would have happened to them.
And he, of course, is talking about that probation violation that sent him to prison for a year after the murders. He admitted to driving the day Abby and Libby went missing, and that was a condition of his probation. He shouldn't have been driving.
And Erica, the biggest part about the alleged confession to Davis, the box cutters. Explain to us the significance of, on 5/15/2017.
Hey, Nick, can you pause it real quick?
Reese talking about.
So the phraseology of they got themselves killed. Now, that implies that they put themselves into a bad place, which implies prior knowledge that they were invited out there. Again, how that was, if I am a mom of 6 who is blonde underneath this and can piece that together with maybe 5 minutes of sleep, you'd think that investigators could.
Yeah, I mean, the phrasing of that is him putting blame on the girls. They got themselves killed.
And completely exonerating whoever killed them, like they had provoked it in some manner.
Yeah. Now, phrasing is just phrasing. He misspoke, whatever, but I don't believe he misspoke. I believe he talked from experience. And I have to, again, I know a lot of people won't like this, but Jennifer Coffindaffer, she was on to this early on.
She
Very early
was,
on.
and maybe,
So
but maybe she
regardless
also
of
had.
every other case she's covering, in this case, she was on this. Myself actually didn't believe the Ron Logan theory at the beginning, but the more info, that's because of lack of information. And all of a
Yeah, and I
sudden this
wonder
shows
if
up.
she had this sort of information that Ron Logan, again, because we've just found this out, or we're just now getting all of this information coming out fairly recently. So these are major things that maybe she had access to on the back end with some of the federal files. So, yeah, she got it right. I mean, she had that pegged before we did, so hey.
Mhm. Yeah, sometimes you have to give props where prop is due.
Yep.
Ron Logan mentioning box cutters.
First of all, there had never been any disclosure at that point about the crime scene, about the wounds to the girls. And so Ron Logan reportedly being able to tell that information to Reese is something that we would expect the killer or killers to have only known. Now, let me take it one step further, Vinny, by saying that had those investigating this case known about that way back when, and we could have, I'll just say this, we could have done a much different response or had a much different response when Orr then testified that he looked down in his workshop, saw a box cutter, and went, oh, murder weapon had to be a box cutter. This actually makes this newly discovered evidence, Vinny, and would have been a great argument for those defense lawyers to bring back in the third party culprit and opening the door to get all of the truth out, not the 10% the public's been given, or maybe the 15 to 20% that the jury heard.
All right. Well, we got to up that number from 10% tonight on this program, Erica. Let the public know a little more. Coming up next, we've got a lot to get to. Did Libby record Bridge Guy's voice?
This has been a major
we talked
contention.
about this
Yes.
in one of our first streams together.
Yes,
And we
because
were ridiculed for it. Or at
Okay,
least I
well,
was.
I was about to say people don't expect much from me, so
Yeah.
they probably just expected like, oh, well, she's a random weirdo, so you know.
Mm.
I am a professional silly person on the internet, so
Yeah, but because I do not remember, because there was something about the articles that we went through, and it just, wait a minute.
yeah, you picked it
These are
out
two-
because two different kind of recordings, or it was never clarified to any degree that the person that you were watching on that clip is the same one that was talking to you.
Exactly.
And there was never any indication that you could corroborate the two together or make them come together and be the same person. It was always just an absolute assumption from the get-go that the person you saw walking far, far away to the point where it was almost like a half a mile away, that was the person that you heard at the end of the recording.
Yeah.
Or
But what they are about to say here now, sorry for spoiling it for anybody, is that the voice and the video are two separate recordings. What the investigators did was they added that to the video just to ask, do you recognize the voice with the person or the voice, just as an investigative tool, which I completely understand. But then they forgot that it was two different recordings.
yeah,
And recorders, and I've been looking at for years. There's an audio recording and a video recording. We show them and play them together, but they're not recorded at the same time. So that video you see of the bridge guy, he is not at that moment in time saying, guys down the hill, guys down the hill. They are at separate times. And for years, I just presumed same person. Like, how many people are going to be there? Like, it's got to be the same person. But now I have a question about it, and it's my next question in our investigation, because this was a recording made by Libby. Did Libby record Bridge Guy's voice? Or was it somebody else's voice? Could there be a second person there who could be saying, guys down the hill? And the video isn't of the person who said that. I don't know. I need this question answered. I think it's an extremely important question. Still with us in studio, Barbara McDonald, and joining me, criminal defense attorney, host of the Defense Diaries podcast, Bob Mata. Okay, I want to begin here. Barbara, I'm going to play another piece of your interview with Ron Logan because it's significant when it comes to what we just saw. Let's take a listen.
And you've been down there, you've seen that.
Oh, that's not an easy walk down.
And he said that because I was able to walk up and down that hill, I was perfectly capable of doing that. They don't realize how much effort it took just to get me up and down that hill.
Right.
I sure as hell ain't going to be dragging anybody with me.
And you heard him say there, get down that hill. So let's take a listen once again to the recording from Libby's phone. Now let's compare that to Ron Logan.
He said that because I was able to walk up and down that hill, down that hill, down that hill.
Okay. Barbara, what do you, first?
That's a hard sell because it's altered. Because it's enhanced, background now is removed. We don't actually know how close to the real voice that recording is.
What interests me more in that sort of interview is him chuckling and saying, I didn't drag anyone down that hill. You don't have to drag anyone if you're pointing a force multiplier at them.
Yep.
So he's kind of giggling like, you don't know how I did it, but you won't see any photos of me.
Do you want to go to my barn and see my horses? Then they walk voluntarily down there.
Yeah, I just...
They ask,
the laugh
oh, where is it? Oh, just, guys, it's down the hill.
Yeah, it's more chilling to me, the laughing. The down the hill part didn't intrigue me because I didn't even focus on that since they're both recordings from a phone. But what did really chill me was the kind of laugh like, you guys, I'm an old man. I can't drag anyone down here. But it's almost like he's laughing at his own joke because he knows he didn't drag them down there. He had help. Or it's just, there is something tonally in that feels like he's the cat that got the canary. That, you know, he knows something that you don't, and he's laughing at you right to your face because you don't get the joke.
Does that sound like Ron Logan first?
I have always been told by experts that the clip of the man saying down the hill is too short to be compared. And I think depending on whose voice you listen to, you can hear a lot of different voices in it, just like you can see a lot of men in the picture of Bridge Guy. But I don't know. I mean, I don't think that his voice is inconsistent, and that was something that the FBI wrote in their probable cause affidavit saying he's the murderer, that the voice was not inconsistent.
Okay, so now let's talk about this, Bob. Let's talk about these two different recordings. One of down the hill, the other of this bridge guy. So where was the bridge guy in reference to Libby as he's being recorded? How much time is there between when he is recorded on video and when the voice is recorded?
It's impossible to know. I mean, it really is. As far as I'm concerned.
Wait. Time out. They didn't just play the video in the courtroom?
I mean, they did, but the sound wasn't matched up with it. You know what I'm saying? We're watching and that was something that I always questioned, and I didn't assume that it was true, even though the government said it was, that the sound was matched up with that particular video. I always wanted to know if, in fact, when we watched that video, would I hear the sound simultaneous to it? And we didn't. I mean, when we watched the video, it was a silent video. And, I mean, as far as I'm concerned, I mean, the distance from where I saw him finally, and when he says down the hill, it seems like he would have had to have closed that gap pretty quickly.
And how much of a gap are we talking about? How much of a gap are we talking about? Because it looks like the video is really zoomed in, because I'm looking at it and, it's very pixelated.
It's really hard to know. I mean,
wow.
I wish that I could say that I saw that video 100 times so that I could give you a better idea. We saw it a couple times each, and there were basically 3 different versions of it: the original, the enhanced, and then, the stabilized enhanced. So, when I saw the last time they showed the stabilized enhanced, it appeared that he was closer. It appeared that he had made some ground up. So, but again, to me, when I'm hearing Libby kind of whispering to herself, where she's kind of narrating in the beginning of the video.
I don't know, because I didn't hear it.
I know, Vinny. It's a real shame. The whole country should be able to hear it.
Barbara, what's your take on this, right? Because this, again, lack of transparency. They haven't released this stuff. The judge isn't releasing it, just entered an order tonight, not releasing stuff that is all public. What is your interpretation of, is that absolutely the bridge guy's voice? Could it be someone else? Was it one continuous video that's recorded that he's walking and then eventually you hear some talking? Or is it 2 separate videos?
We've been told it's one video that's 43 seconds long, and she does kind of move the phone a bit as she's recording that video, so it's not a static shot of the scene. And then, the other thing people point out all the time is your phone is pointing at whatever you're videotaping. Stuff off to the side and the back, you're not going to see, right? You're only going to see what the phone is actually recording. And so, was there somebody else there? We can't say. The video doesn't determine whether anyone else was behind Libby.
So he's not on video when
he's speaking.
When whoever.
Okay, now they are going back and claiming it is in the same recording. But I do remember the releases, the articles we read about how they released the video and then added the sound to the video. So I'm still saying somehow.
Well, this is gonna. I have always had an issue with this, and I don't want to discount that. Maybe, she was actively taking pictures of this creepy guy she saw behind her friend, Abby. But Libby was filming Abby's first walk across the bridge. And I know that it is heartwarming to think that she had the situational awareness that I don't think any 13-year-old girl generally does, because I've had them, to, kind of point out and notice a suspect person coming up, behind them. I don't think that's what happened. I don't think that she was actively trying to take a picture of this person. It makes much more sense that she was just filming her friend. And with the clarity that you hear this behind makes sense. Because, again, Bridge Guy was way, way far back to the point where they had to interpolate it. So he would almost have to run across that bridge to come up to where you're... Because you've tried recording stuff with your iPhone. I mean, there's any wind, there's anything, you're not going to get that crisp, it's, guys down the hill.
Yeah, it's strange to say Bob said there were audio playing with the video. He didn't say this audio. Yeah. So
true.
Was the audio matched up with the video? That was what the question was. And so for some odd reason, because if everything was on the same video, you don't need to match it up.
No. Then I wonder what happened to the. What video do we get the speaking voice from? What is that
Yeah.
video of? I mean,
Yeah.
even if it's a black screen, indicate that's a different video.
Whoever is speaking.
Right.
Did
And
it
the
seem
words.
did it seem like the recording was done purposely to take a video recording of this man walking over the bridge, or was he caught in the background of a video?
He was sort of in the background of the video, but perhaps if she was in fact concerned and that's why she was making the video, perhaps she's trying not to be too in his face about the fact that she's recording him. And so it did appear to me as if she might have been just holding her phone as if she was just holding it in her hand and not recording, to perhaps appear as if she's not recording.
So what's the, I've watched a lot of trials, Bob, a lot. I mean, that's what I do for a living. And whenever like a piece of evidence like this is presented in court, they press play and it goes. I'm just getting the impression that it wasn't as straightforward, or was it? Did the jury have did they have some sort of enhanced ability to understand this and see it? Did they have like personal monitors right in front of them? Did they have the video in the jury room? Do we know any of that?
As far as the courtroom, no. We had a big screen, about an 85-inch monitor that was stationed probably about, let's say, 15 to 20 feet away from the jury box. They had no headphones in terms of hearing sound. They certainly didn't have individual monitors or even a monitor near the jury box. So we were all watching the same thing, aside from the attorneys in the room that had their computers up. Man, I mean, and it's like, we knew it when it's coming. So it's like you could tell that it was coming, that they were going to show it. So I was really anticipating it, like everybody else. I'd been waiting for years. I wasn't been lucky like Barbara and hadn't seen it before. So I was dying to watch it. And so that I'm like paying rapt attention for that 43 seconds. And man, it went in the blink of an eye. Like the first thing I did is I turned to the person next to me. I'm like, was that 43 seconds? Because it was so quick and you're trying to take everything in. And man, and then you see the next video and it's different. It looks different. It feels different. It sounds different in terms of when they play the sound. And I'm like, what did I just see? Like what did they change? Were they able to access both the front and back camera? Like I couldn't tell what I was seeing, and you're just trying to digest it all and you're just trying to make sense of it all. And it's like that thing where I was talking about though, like where you hear Libby she's really kind of narrating. She's talking about the rocks on the side and, there's the little path down there. Who's she talking to?
Yeah.
That's always my biggest thing, so it's a mystery.
Still unanswered. Okay. Guest staying with us. Up next, where was Ron Logan on two
I doubt she was
wonderful
talking to
young girls?
anyone. Every kid wants to be a YouTuber now. My kids want me to set them up as YouTubers too. I'm like, oh Lord. The worst idea of tech support ever. Me.
But they can be. No, they don't want to be a guest on my Friday drinking show.
They probably would, but they'd be like, oh wow, when mommy drinks that, she just goes to bed.
When Nick drinks that, he goes to sleep in front of the camera. Oh.
Those are a lot of curse words. Could you please write down that one that starts with a C again? I'm going to need to use that one day.
Yeah. I can teach them some Swedish cursive words.
Ooh, please do, because then I will just think that they're saying Gesundheit, and I'll be like, oh, that's so sweet. You tell everyone that when they sneeze.
Yeah, I mean, or...
Oh, the new Snow White.
Oh, no. No. Oh,
She has the Lord Farquaad hair. I'm sorry, she does.
Oh, I'm supposed to be on laid back law in 13 minutes, and we have 20 minutes of video. I already told Eric that I might be a bit late because.
Do you want to try to go 1.25? And
Yeah.
if we just let them talk, then I will try my hardest. But then we can't let them talk because then copyright. Damn.
From Indiana, Abby and Libby. This is one of the most secretive investigations and trials I've ever covered. A lot of evidence was excluded, and now many are wondering if justice was served. Here's the story. Teenagers Abby Williams and Libby the Hater saved lives of these two in the Richard Allen Waite that the jury didn't hear about during the case. Top of the list is Ron Logan. It was his property where the girls were found. So obviously there's a nexus from day one. Take a listen. This is Barbara McDonald, Court TV's own, speaking with Ronald Logan.
And so, other than being on surveillance at the fish store, is there any other evidence that proves you didn't do it?
Well, I don't know why you would have to have anything else. When the girls were being murdered, and I'm in Lafayette, how much more do you need?
So Ron Logan had an alibi that he was at the fish store buying some fish. You put it in the bag, you bring them home, the fish in Lafayette, which is a bit away from Delphi. But then you have this. This is from Ronald Logan's probable cause affidavit. On March 12, 2017, David Nulf, Ron Logan's cousin, explained in an interview to a law enforcement officer that Logan called him on the morning of February 14, 2017, and asked him to provide the alibi for Logan's drive to the aquarium in Lafayette. He's trying to get his cousin to vouch for him. Hey, I need an alibi. Like, kind of suspicious, right? So that brings us to the next question in our investigation. And it's about Ron Logan. Where was Ronald Logan on the day of the murders? Pretty important, right? Joining me here in studio, Court TV senior producer. She's an expert on the case, has covered it from the beginning, done extensive interviews, including what you just heard, Barbara McDonald, and private investigator who is close to Richard Allen's family, the convicted killer here, and founder of Victim News Online, Erica Morse. Okay, Barbara, do you know anything else about where Ron Logan was that day?
So he claims that he was at the fish store while Abby and Libby were being murdered. Earlier that morning, he had driven himself to the local refuse station to throw away big green trash bags that he said was his household trash from his home that animals had gotten into the night before. And so he spent the morning of the 13th bagging up all of this trash that animals, he says, had strewn about his property. He was very, very angry. Here's some pictures from the surveillance camera at that refuse center where he drove and was able to dump these bags of trash. Now, he only sought the alibi from his cousin for the trip to the fish store. So he wasn't trying to hide the fact that he was driving because he had driven there. He had talked to employees at the refuse station, so they knew that he was there that day. And so that's what he was doing that morning. And then in the afternoon, he has always said that at the exact moment Abby and Libby were being murdered, he was in Lafayette. That cannot be proven. There was no surveillance video at that fish store. And so nobody knows exactly what time he got there. His receipt for his fish purchase was at 5:21 p.m. For his alibi to be correct, he would have needed to arrive 3 hours prior to that. And it's a very small fish store. I doubt he was there for 3 hours.
There's not that many fish in the sea.
There's not that many fish.
Okay, Erica Morse, in any other investigation, if you had victims that are found on this man's property, he's lying about the alibi, and there's video of him the next morning throwing away bags of something. Oh my goodness, we'd be jumping up and down and screaming. What are your thoughts about where Ron Logan was on the day of the murders?
We know from cell phone data that Ron was on his property on that morning. Barbara's right. He made that transfer station run. Now, it's interesting because I believe his ex-girlfriend disputes what he may have been throwing away at that transfer station that day. She claims it was her belongings. But let's also establish what Ron Logan is saying here that might be tripping himself up. First of all, I'm curious how Ron Logan could know the exact time of death when there was no time of death determined in this case. So
you're muted.
Yeah. Sorry. Yeah. How did he know the timing of his alibi?
Well, it just goes back with everything else he said. I did the older girl first. They went and got themselves killed. I mean, Again, his phraseology was weird. And again, that's not something like at the exact time that they were murdered, I know I was somewhere else. That was never released. Even
No.
the state's kind of iffy about their timeline.
Yeah. And the medical examiner, there's no time of death because it could be from when the phone stopped until we found them, and anywhere
Yeah.
in between. So we don't really know. But he knows when to have an alibi before. I don't even know if the medical examiner had made that statement yet that he didn't know the time of death when he provided an alibi.
Well, they didn't. Anything that Ron Logan told Barbara was going to be prior to this case going forward. I mean, Ron Logan died, I think, 2 or 3 years into the investigation. So he is going to know prior to this having been released or even put into a timeline.
Yeah.
How?
Well, that really stuck out to me. Ron said that he got to the aquarium store around 3 o'clock, but then he backed up in the alibi request from his cousin, asked him to back that up an hour. As Barb said, it's only about a 20 to 30 minute drive to that aquarium store. So there's about 3.5 to 4 hours unaccounted for roughly. But my issue remains that consciousness of guilt, needing an alibi before anyone necessarily knew an alibi was needed, and claiming to know from his perspective when the girls were murdered, because none of us know that. For some reason, he does.
And Barbara, getting back to what you said, I want to make sure this doesn't go under the radar on this program about he claimed that he wanted that alibi because he wanted to say that his cousin was driving because he didn't have a license. But like you said, he's speaking to people at the refuge center and is driving and is on surveillance
no alibi
video.
for that. No lies about that.
But didn't ask him to lie about that. That does not make sense. One other thing I want to put up on the screen, this is from the Ron Logan probable cause affidavit. An analysis of Logan's cell phone data revealed a text message received by his phone at 10:16 p.m. on February 13th, 2017. Initial examination of his analysis indicates Logan's phone was likely outside of his residence and in the proximity of where Libby and Abby's bodies were located. This is extremely important, Barbara.
It is.
And excluded by Judge Gull.
Well, it wasn't a nexus.
Yeah, that the person owning the property was roughly where the girls were found at just after 10 p.m. the night of the murder.
Nicholas, I mean, is that guy's named Richard Allen? If not, then we don't have to pay attention.
Yeah. And Broken Bakerade. We got a Bakerade. That sounds like a Danish drink. Bakerade.
It sounds like something like a really cool new mixer. Like, this is your new Bakerade. It's going to help you knead and, form little cakes and canapes. Get your Bakerade today. Or like a energy drink that keep bakers awake early in the morning. Like, you have to get up at 3 to make sourdough? Try some Bakerade.
Yeah. Welcome, folks, from Broken Baker. We are talking about the revelation about new evidence being revealed in the Delphi case. That burner phones that were on the scene, according to either a cell tower dump or geofencing, burner phones were at the scene at the time of the murders. Same burner phones were at the scene of a 2012 abduction and murder of 2 minor girls, excluded from the trial by Judge Gull. And also new information about Ron Logan. And so we started talking about the Delphi case about an hour ago. We are 12 minutes to go of this. And I'm supposed to be at Laid Back Law in 4 minutes, but I already told them that I will be a bit late. So go back an hour, because this is going to infuriate you.
Yes.
Absolutely infuriate you.
One of the defense witnesses at trial testified that somebody plugged an auxiliary cable into Libby's phone at 5:32 p.m. after the murders, after the time the state says Richard Allen would have left the scene, and then removed that auxiliary cable at 10:32 p.m. The FBI said Ron Logan was in the proximity of the crime scene at 10:16, so that definitely does not look like a good fact for Ron.
Okay, Erica, what else should we be thinking about and talking about here relative to Ron Logan or anyone else that he may or may not be connected to?
So Ron was a staple in that community, and there were a lot of rumors swirling. And you know what? This case is one where people want to talk, but a lot of people don't want to come forward and come on the record. And that's been probably, from my perspective, the most aggravating aspect of this is you can't investigate in a vacuum. You have to go out and talk to people. Well, a lot of my conversations have been trying to convince people to go on the record, to sign an affidavit, to sit down for an interview with lawyers. And it's been very frustrating to get people to take that step because a lot of people in that community are afraid. And that's not a secret to the many hundreds of people, the YouTubers, the journalists, the PIs, the looky-loos, everybody who was really trying to drill down in on this. But, you know, there's also some other stuff that's come out this week. Mike Osbrook, I think, blew a lot of us away when he mentioned on a YouTube the other night, Vinny, that according to Mike, there were 2 phones in that geofence area.
Since then, he said, he never mentioned any geofencing. No, but he did mention burner phones in that area. And she says geofence area, not that it was geofenced. So it could be a tower dump, it could be anything, but that he actually mentions the burner phones.
That also appeared in the geofence area back in Evansdale, Iowa in 2012 when Lyric and Elisabeth disappeared. And our camp, our crew, has spent the last several days talking with some folks in other states. I told you a couple months ago we were looking at other cases on this. There is a very strong indication from a lot of the work we've done over the years that several cases involving missing.
Geofence area is when you take a cell tower dump, you get what phones are within reach, and then you can use the numbers and stuff to see where in the area to narrow it down. That is a geofence area, so it's more narrow than the cell tower dump.
Yeah. Well, and it's also going to be pertaining to a place where you want to see who all was in that area because it's linked to a crime. So you wouldn't geofence, Walmart if you were wanting to look at the Delphi crime scene. You would geofence, maybe 3 miles surrounding that general location at that time. So it's a specific, area in relation to a crime scene and a specific time period they believe that crime has gone on. So they can't just geofence, everyone who was in the state of Indiana on the day of the Delphi killings. I mean, they could, but you'd have a lot of random noise.
Children tie back to prepaid burner phones sharing inappropriate materials of children. And I'm telling you, we have only reached the surface on this. There is so much more to go. And when I got the call 2 days ago about what Osbrook had released on YouTube, we went back through, yet again, more notebooks. Now we've got a detective from another state reaching out saying he wants to talk to Christine, who Barb knows is my partner in anti-crime. And we've got a lot more questions. With every day and every new piece of information, every new tip that's being called in, we are nowhere near close to the truth yet.
All right, Erica Morse is going to stay with us. Barbara McDonald, thank you so much. Incredible reporting as always. Still to come, what is next for Richard Allen's defense?
Richard Allen, you child murderer!
Without this verdict, fighting for a new trial. It's his only chance to get a new trial. But while they're fighting for a new trial, they want to make sure all the evidence they want to present to a jury at a new trial doesn't disappear. So they had filed a motion to preserve evidence. Well, the judge has ruled on that. Take a look. Yeah, this is the judge's order. Defendant's motion to preserve specific evidence is therefore denied without hearing. Not surprising. Anyhow, so what happens now? Brings us to our next question in our investigation. What's next for Richard Allen's defense? Legally, in terms of investigating, where are they going? What are they going to do? Joining me, criminal defense attorney, host of the Defense Diaries podcast, Bob Mata, and still with me, private investigator Erica Morse. Bob, I'll begin with you. Legally, what do they have to? What's the road here that they have to take?
The appeal, the direct appeal will be first, and she most recently has denied, without hearing, of course, the motion to correct errors that was filed that had some of the pretty interesting factoids that were laid out for the public to view with respect to some potentially other culprits, and which I thought blew apart the timeline. She wasn't interested in hearing that, but it's part of the record, which is the important part, which is where we're going now. I mean, post-conviction, Vinny, you know it, is a long process, and it'll start with direct appeal. The notice of appeal will be filed within 30 days of the entry of the final judgment. And, then they'll start getting the record put together, which I'm imagining they're doing now. And at that point, the briefs will be drafted up and they'll be submitted. And at some point, they'll be argued, and then a decision will be rendered. And then if it's successful and they decide to remand it and kick it back for another trial, it goes again. The question of whether or not Judge Gull will sit on it is unknown. I mean, if she's not removed by the appellate court, I imagine she would be sitting on it again unless she recuses herself or says, I don't want to do it again because it's dragging me away from my own county. And if that's not successful and the direct appeal is denied, it goes up to the Indiana Supreme Court. And then, there's always the post-conviction petitions that can be filed, which that's where you can bring in newly discovered evidence. And a lot of the things that we're seeing currently, that's really more where you'd be seeing that kind of stuff show up in the post-conviction work in terms of the post-conviction relief petition.
All right, Erica Morse, this was a motion to preserve specific evidence. And so what is this evidence going to disappear? Or what's going to happen to it? What type of evidence are we talking about? And where does the investigation for the defense go now?
In terms of what evidence, I mean, I don't want to speak to anything specific. However, there were some things listed in that motion to preserve: the belts, the handkerchief. There are a couple of items that I know of. Those things have not been tested.
Yeah, belts, plural, not belt, belts.
Yeah,
and
this
other
is
stuff. And also through the grapevine, there were more phones in that area than I ever knew that was collected. Lost phones or something like that. That may or may not have been there at the time or after, we don't know, because they won't release it. They won't release the information. And apparently, this place is known for hunter stuff. So there's a large collection of bullets and casings that was never tested. Just that one, the recycled one.
that was magically found 3 days after the crime scene was released to the public.
Yeah.
That we have no pictures coming out of the ground, but like holding it in their hands for cereals.
And I think they absolutely have to be tested, kind of especially based on some of the conversations on how that was discovered, and maybe it wasn't known to the defense in time for trial. I think that they need to get their hands on those receipt letters. That, to me, from an investigative standpoint, is key, because it references a third person. We've narrowed it down to 2 in that one, and then there should be this third person. And I think that when cross-matching that against the Frank's memo allows for a very narrow focus as to who that third person might be. I know there are people who desperately need to be interviewed. There are new people who have come forward since the trial, since the verdict, since the motions. I know that I've been asked to be debriefed. Christine's been asked to be debriefed as recently as last week on our notes and some interviews that we've conducted over the years. So there's a lot that still has to
Let me ask you this,
here.
Erica. Do you think that Odinism is still you mentioned the Franks memo, and that's where all the Odinism information came. Do you think there's a potential connection between Ron Logan and some of these people who were investigated and alleged in the memo to be Odinists?
Absolutely do. I absolutely do. This is not over by a long shot. I believe that there are a lot of people who are really close. And somebody said it best today. I saw a YouTuber say it best today. If we could have one consolidated place where everybody who has touched this case could centralize that information, you know, like law enforcement does, then it would expedite this, I think, because there are a lot of internet sleuths touching this. There are a lot of PIs who were brought in throughout the years on this case as fact finders. And I think that everybody has their own systems and their own information, and it necessarily hasn't all gotten to the right place yet. And so I'm very hopeful that that will occur over the next few months.
Well, Bob Mata, Erica Morris, I appreciate your insight, your valuable time, and I think we'll be speaking about this one again. Thank you so much. You know, it's difficult to have an extremely strong opinion for me about justice in this case. And that's because of two reasons. One, the judge did not allow the jury to hear alternative theories uncovered by investigators on the task force that were looking into this case. And two, the judge prohibited cameras and electronics from the courtroom. So only a handful of people actually saw the evidence. Here's the bottom line. Lack of transparency always results in lack of trust. I'm Vinnie Politan. We'll keep digging for the answers as this investigation continues.
Yeah, and big props to Vinnie.
Yeah,
For doing this, because there are a lot of YouTubers on this case, but Vinnie is on another level. This brings, it brings some. He has trust. He has people trust him. While people who just show up on one of my videos or streams, who is this jackass? But everybody knows who Vinnie Politan is.
True. And, you know, again, while it's intriguing to maybe have this linked to a big conspiracy of gross people and link it to other cases, I do have questions about why all of this wasn't looked into. Because we didn't have Richard Allen until, 2 years ago. Are you telling me that they just all were willfully blind and ignorant to these other leads until Richard Allen, a useful outsider, people started getting upset? It started affecting their votes in the local sheriff's, election.
Yeah. And Richard Allen, probably one of few outsiders. Remember, he's not native to this community.
No, he's from Peru, Indiana, I believe.
Yeah. So every adult man in Delphi, Indiana, know each other, it seems. They went to school together. Their dads went to school together. They are more or less, all of them are local masonries and Odinists. Many both. However, that is possible. But, so yeah.
Well, and they were probably banking on overworked defense attorneys who weren't going to take the time or even look out at that. They probably figured that as long as they had, the monster caught, that the other detectives were not going to feel, ethically motivated to bring up these other leads because we had given, the community an easy answer.
Yeah. Yeah. I need to do.
Absolutely. Thank you for having me on.
Thank you for being here as always. And I say this, as I said before, when this channel becomes this enormous, so I can hire a constant sidekick, you're it. I will hire you in a hot minute.
That would be great because I don't want to do all of the managing stuff. So I just get to be a professional silly person and you can do all the thinking stuff.
Yeah.
We are sold.
All right, everybody, thank you for tuning in. I'm going to redirect you to Laid Back Law. I'm going to talk about the Delphi case there. And I don't really know all of the subjects that is going to be talked about there, but I will talk about the Delphi case and these new revelations. So I will see you all over there. You on X, you know who Eric is. You over at Rumble probably also know when that Eric is on. And for you at YouTube, Laid Back Law. It's already started, so I'm going to send you over there. So thank you guys for being here. Thank you to the new member, Idiot Wind, and who also made a very, very generous 20-pound super chat. Thank you so much. So I'll see you over there, and have a good one.
Bye,
See ya.
guys.
Bye-bye.